Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And as always, I hope you're just having the most fantastic day. We turn our attention once again to the taking care of Maya trial in the post-trial motion hearings. This is the motions principally brought forward by Johns Hopkins in relation to, we don't really like the jury's verdict very much. Would you consider maybe rendering a verdict in our favor instead? Judge, would you like to do that? Oh, and also, we don't really like these damages very much. Would you like to consider reducing them to maybe 0.5%? Maybe $3 or $4 million sounds better to our taste. Or, the motions against juror one, who may live with his wife. He may live with his wife, and that is potentially a problem in some way. And some related stuff to that. So that is where we're in this morning. So there's going to be no evidence this morning taken. This is just a hearing. It was clear on the court's order, just a hearing. We're going to let them have oral argument about this stuff for a while. We're not expecting a decision from the bench today. The judge in their order said that they didn't anticipate making a decision from the bench. So we're expecting this to be a hearing, and then at the end of this, the judge take under advisement and tell Johns Hopkins no. And then the exact nature of how he tells them no, of course, will be interesting. I'm hoping no comes in the form of a bar referral by the judge to the attorneys, if not for any other reason than for the slanted S means secret Nazi communication, which I found to be well below the belt. And also, I believe that Maya's lawyers, by breaking juror one into this, and his wife, and then secret Nazi thing, have violated Rule 8.4 of the Rules of Ethics because they've disparaged the juror for no reason. And I believe that they've committed an ethics violation and should be held to account by that. Plus, if that wasn't enough by itself, they have repeatedly violated court orders, as we've noted, and also engaged in deceptive things to the court. And I look at this in a couple different ways, right? It's like how I try to think about this. It's like, I don't have the feed. Yeah, I don't have the feed yet. I look at this in a couple different ways. Like, there's a difference between like the case and the lawyers in some ways, right? Because I think it's possible to be critical of the jury, at least in sort of the amounts they awarded. I think that's a perfectly reasonable thing that a person could do. So, to the anti-Maya crew out there who exist, if you're thinking to yourself, these damage numbers seem high, I understand at least some of where that's coming from. You might not think the harm that happened to Maya was bad enough to warrant these numbers. And I think a reasonable person could potentially form that opinion. But of course, at this stage of the proceedings, we're concerned about what a reasonable person could find with respect to the non-moving party, right? So we're looking to preserve the status quo. And the status quo at this time is that Maya wins, right? The status quo at time zero was John Hopkins wins because they're assumed to be right because they're defendant, right? The status quo at time zero is John Hopkins wins. Well, we've had all of our process in our hearings and, all that at this point. And this has been going on for some time with apparently the 35 motions and 15 orders for the iCloud data, or 15 hearings for the iCloud data, and 52 summary judgment orders and all the rest of it, right? So this has been going on for quite some time. And the jury also was presented with information, although perhaps not enough, because Johns Hopkins seemed to not avail themselves of obvious opportunities. But they at least were presented some information by Johns Hopkins to show that, maybe her pain isn't that bad, social media that shows her, partying and all kinds of stuff. And so you could do that. Although Johns Hopkins then their lawyers seemed to miss an obvious opportunity to have their own psychiatrist come in and testify about Maya not being really that hurt mentally, because they could have done that, right? Because they could have gotten a court order to have Maya examined by one of their psychiatrists, because she's putting her own mental health in issue, right? So yeah, it's like it's that thing, like it's either in for us all or out for us all. So you of course have the right to keep your medical information out of the proceedings, but once you bring it in, it's in, right? You can't have it both ways. So like if you bring it in, you're waiving your own privilege, because they obviously have the opportunity to cross-examine you on that. And so they could have gotten their own their own psychiatrist of their own choice to examine Maya and get up on the stand and say, the things that happened to Maya were not too bad. And I think there's a lot of ways to go about doing that. Yes, I'm going to be streaming the hearing. Why do you think I'm up this early? Yes, I'm going to be streaming the hearing. So I'm just giving an update or an introduction, because we're waiting for the court to start. So am I going to be streaming the hearing? Lol. So, that's sort of where I'm sitting. And I think it's difficult to find that Johns Hopkins didn't commit the underlying actions. And we've seen certainly evidence from that as it relates to medical negligence and false imprisonment, particularly for the period at the start where they had no court order and kept her for 6 days when they didn't have permission. Yeah. I'm awake. This is my awake face. We're awake. We're doing fine. I'm talking to you. Don't give me a hard time. It's early. So yeah, we're just waiting for that all to start, and we'll see where we go. And I don't think this judge is particularly inclined to help Johns Hopkins out at this point, because their own lawyers have made it so difficult for the judge to want to rule for them, and that goes a long way. There is rule number 1. There's a new stream up on Top Mark. Oh, different stream? Oh. I was deceived. Maya's looking very good today. Happy birthday, Maya, by the way. Happy 18th. You're looking very good today in court. I'm not sure necessarily why she's there, by the way, at this point. She doesn't necessarily need to be there. There's no particular reason for her to be there. I mean, she's obviously welcome to be there. It's a public courtroom, but there's no particular reason for her to be there at this point, but okay. Or Jack or the son. There's no particular reason, but they want to come here. And yeah, Maya sure is beautiful. I agree. Since she's 18 now, I can say this. Hey, Maya, holla. Sounded scratchy? Oh, they said on the, yeah. Dr. Joe is there? Okay. Hey, she's 18. It's legal, man. It's legal. Don't hate on a playa. Hate the game. Yeah, the Nazi accusation, I think, will be discussed today. Legal doesn't make it non-creepy, then we'll just agree to disagree. Just raw curiosity, was the threshold for creepy in your mind? Oh, Lord. I don't know why it's creepy for 2 consenting adults to want to be with each other. And so if she wanted to be with me, then, that's a good thing. 20 years. Okay. Yeah, good morning. Is Jules there this morning? Notorious. Ooh, 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 ooh. Notorious. See, your late husband was 19 years older than you? There you go. Yeah, there you go. See, that's what I'm talking about. Notorious. No, no, notorious. Jules. After age plus 7, and I don't know who invented that rule.
Just give me a moment to get the computer going.
Juror 1 does not have to be there. They said this would be a non-evidentiary hearing.
Case number 2018 CA 5321 Kowalski versus Johns Hopkins All Children's Hospital. Starting with the plaintiff, let's take appearances, please.
Greg Anderson, Nick Whitney, also we have Tom Elliott and Amy Ferrier, and then by Zoom, Samantha Lawrence and Jennifer Anderson on behalf of Plaintiff's Strong.
Howard Hunter with Chris Altenburn, Ethan Shapiro, and Pat Crowell for Johns Hopkins All Children's Hospital.
Thank you. And I assume everybody got the agenda that we're going to follow this morning in the second amended order. So why don't we just get right to it. First topic is going to be the issue of alleged juror misconduct, whether we should be having a hearing, and if so, what the contours of that hearing would be. Mr. Shapiro.
Yes, may I approach the podium, Your Honor?
Yes, sir.
May it please the court, Your Honor, I actually break this down into two separate and distinct arguments, either of which would warrant a new trial and at a minimum warrant the juror interview. The first is the duty of jurors to adequately and honestly disclose during voir dire any material issue that could affect their jury service. In this case, juror number 1 has 3 material omissions or misrepresentations based on his verdict form, and I'll discuss all 3 in turn. The first was he was asked on his juror interview question whether he or an immediate family member had ever been a victim of a crime, and he checked no. We've since discovered that both he and his wife had filed an affidavit and prosecuted their stepson for threats and looks like what was being threatened as a murder of both of them in the form of a sworn affidavit to Detective George Richards on March of 2016. There's very detailed statements about this. I think they're part of the record, but if not, if I may approach and hand Your Honor a copy.
Yeah, this is new information. This is not part of the record. What the hell are you talking about? And you're just bringing this now, just in the court, just a second?
This cannot possibly be something that a juror would forget to disclose. This was a question directly asked, and as Your Honor and the court would review the affidavit, there's multiple instances in here where both juror number 1 and his wife state that their safety is at issue, that there were threats made against them that they wish to prosecute. That's certainly something that if disclosed, there would have been multiple follow-up questions and likely a peremptory challenge used. The second is one that we did make part of the court record. Obviously, we apologize for the sensitivity of this, but we have to make it as part of the record.
No, you really don't.
That in 2002, juror number 1 was served with an injunction for domestic violence, of which there's a sworn affidavit of child abuse. That file is obviously sealed, so I can't see what the allegations are, but they are part of the record. That would be something that they would have a duty to disclose, both during the questionnaire and during voir dire. This was never disclosed, as Your Honor can imagine. Had that been disclosed, that certainly would have led to a cause challenge, if not a peremptory, if the cause challenge was denied. The third, we learned,
20 years prior to this trial?
yes, Your Honor. The third was in the questionnaire prior to the one given to the witnesses. There was a list of witnesses that may be present, of which there was Deborah Salisbury. Deborah Salisbury, as we've learned and as we filed with the court, it turns out she was juror number one's wife's attorney for her divorce proceedings, the same attorney who represented Mr. Kowalski. That was never disclosed to us either. The case law on this is very clear. Under Rule 1.431, we're entitled to an interview of the juror if there's a reasonable basis, and I'll get back to that. But I think the controlling case law on this that's really undisputed is the De La Rosa case from the Supreme Court of Florida at 659 Southern 2nd 239. There's a three-part test utilized to determine whether a juror's non-disclosure of information during voir dire warrants a new trial. The first part of the test is that the complaining party must establish that the information is relevant and material to the jury, to the jury service in this case. All three would be material and relevant, but certainly in a case where there's allegations of medical child abuse and a juror has been served with an injunction for child abuse, that's something that we would have to know about. Certainly being a victim of a crime, especially one involving one's family member, would be something we would need to know about, and both of those were withheld from us. The second test...
Let me ask you this.
Yeah.
And I haven't gone back to look at all of the juror questionnaires, but were there other juror questionnaires where the juror checked family member's been a victim of a crime, and then did your side ask questions of those individuals?
I haven't gone back through all the voir dire, but...
Well, you're making a statement, a very express statement, that you would have used a peremptory challenge, and I'm just wondering if it was so important when that question was asked for other people, what did you do?
Nice
the
question.
law on what I'd have to go back to my voir dire questions and see what would happen, but I know that in each individual, for the questionnaire, all of these were asked by the court, if you recall, and that the court asked those questions. If we had follow-up questions,
Yeah, very
during the
nice
individual
question.
Sessions, we would have
Mike,
asked them if it was
you're
material
saying
to
you
the
would have
case.
followed up. You said you would have
Certainly,
asked all
if,
these questions. You say
somebody
you would
was saying they were a
have issued a
victim of a
peremptory.
crime involving
Okay,
another family
did you?
member, I absolutely represent to the court. That would
Good
be
question.
something I would have followed up on. We'd no basis to, and in fact, the case law says under both State Farm Mutual v. Lawrence at 65 Southern 3rd 52 and Westgate Palace v. Parr 216 Southern 3rd 747 that the counsel is not required to delve further into questions on the questionnaire if the answer is no. So there's under the...
Yeah, but your whole point is if he had said yes, oh dear. Your whole point is if he had said yes, you would, so yeah, your whole point is if he had said yes, you would have inquired. And so you're citing law. It says, well, if he says no, we're not required to ask any further questions. I'm like, okay. But your whole point is if he had said yes, we would have inquired. We would have asked follow-up questions. We use a peremptory. Okay. Did that happen for any other jurors? So you can demonstrate that, did any other jurors check yes? Did you ask any of the other jurors these questions to show that it was really that important to you? So I can demonstrate from your conduct that, yeah, that is really what you would have done. Yeah, that's a pretty good question. Because the lie has to be material. The lie has to be material. So first of all, you have to say the juror lied. And second of all, the lie has to be material. Incidentally, by the way, that's just generally a requirement for lies. Generally speaking, in criminal systems as well. Although materiality is usually easier to find, but strictly speaking, it's not illegal to lie to the government. It only has to be a lie that matters, but usually they find a way to make it matter, but I digress. But, yeah.
Is a very real,
So, yeah, so if they had other jurors that checked yes and you didn't do this, then it undermines that it would matter.
Try to move along. I didn't bring the PowerPoint to run. Been filed with the...
I'm sure Recovery Addict is doing his best, people. Give recovery... Long crime is up? Okay. Yeah, give me a second. I'll switch
line
feeds.
of this and see that the alarm go back, even if it was filed on October 12th with the Sally Smith's name spelled in the SS logo, and we filed that with the court. We're not accusing juror number 1 of being a Nazi. But
Let me ask you about
yeah,
that. Every single juror question, my habit was to read the question at sidebar, and since I'm right-handed, I would use my right hand and turn it over, and almost always I handed it directly to you to look at. And so not only did you hear the question, you had the opportunity to physically look at the sheet. And then about halfway or 2/3 of the way through the trial, your side asked for a copy of all the juror questionnaires. That same day, I had the clerk provide them to you. So you had them. So why was this not addressed in
Preach it.
your
Preach it. You had them.
motion?
You had them in hand.
That was made, you waited a couple weeks, but then you made a motion to disqualify the juror, but said nothing about this. So how is it that this issue isn't waived even before we get to the merits of the issue?
we frankly did not appreciate the difference in the lettering, Your Honor. Had we appreciated it, we would have raised it.
I don't understand what you mean. You couldn't tell that the S was different than other questions, or you didn't know
Reddit hadn't
that,
told us yet. Say it.
This
Say it. Say it. Reddit hadn't told us yet.
was in your mind what you were
Say
so definitively saying is evidence of
Say it.
juror number 1 calling Sally Smith a Nazi. So, I mean, what is it?
Well, with respect, Your Honor, I don't think anybody, including the court, appreciated the difference in the lettering in the moment. Had we done so.
Well, your second supplement is extremely definitive. And so I'm wondering, 1, why is this issue not waived? And 2, what is the good faith basis for the statement and the assertion you made, or actually Mr. Hunter made in the motion?
What other plausible explanation would there be for distinct lettering
You've got
for
to be
Sally
fucking
Smith,
kidding me.
especially in the eve of Mr. Anderson giving interviews to Court TV accusing the defense of following the Nuremberg defense of we're just following orders? Had this been only an isolated situation where one juror question has different lettering in the absence of any other suspicion of hostility, we may share this court's view that that would be an extrapolation. But
My recollection is that you all made a big stink about Mr. Anderson's interview that next day, and we had to talk about it and discuss it. So
How is Mr.
I don't
Anderson
see how
relevant to
you
the
can say you
juror?
didn't appreciate the issue when you physically saw the questionnaire and you were later given it during the trial. So why is this issue not waived?
these issues are, from a legal standpoint, a procedural standpoint, the motions for new trial and requesting a juror review are preserved as long as they're brought within 15 days. There's no legal obligation that we can see that all of these issues need to be timely brought during the trial. Now, certainly, Your Honor, had we appreciated it, we would have added it to our motion. But given the breadth of it, I did not appreciate the different lettering at the time. That's all I can tell you. And it sounds, I don't think the court did. It wasn't glaringly obvious to us as we're reading questions from the bench and focused on the substance of the question.
Well, how did you come to appreciate the difference?
Somebody pointed it out to me.
Who pointed it out?
Continue.
Say, ask who.
On October
Ask
19th,
who pointed it out. Say it.
We
Damn
put a lot of the social media postings of juror number one's wife. And look, spouses of
Damn it, Judge
jurors are
Carroll.
entitled
Ask
to
who.
opinions. That's not the issue. The issue is a lot of what's posting here. And I don't think the plaintiff is going to argue in rebuttal that her postings are not extremely pro-plaintiff. That's not even the issue directly here. The issue
sure?
is, given the hostility of juror one's questions and timing his questions to what she's posting online, gives a very strong presumption that they were communicating. Starting on October 19th,
No.
juror number one juror number one's wife was posting online about the lineup for the next day that included Detective Stephanie Graham. And then the next day when Detective Graham's on the stand, she's posting in real time on social media that her husband's going to have questions for Detective Graham.
Well, let me ask you about this. Because anyone who was at the trial knows juror number 1 was basically going to ask questions. Maybe not as certain as death and taxes, but probably as certain as there's going to be a traffic slowdown on I-4 around the Disney Champions Gate area. So how is that evidence of inside information?
Judge, again, if this is the only instance of juror number 1's wife predicting who he's going to ask questions to and when, again, in isolation, if that was the only issue, I would appreciate it. But as we lay out, there's about 15 more instances that combine with it.
No.
You know, and even in, you know, again, in real time, I appreciate the court shared the email from the woman from South Africa questioning the integrity of the Kowalskis. We call her the agent, regardless of what she is. She's, you know, you remember Jules in the courtroom. She's been online saying she was texting with Maya, texting with the Kowalskis. She's calling into YouTube blogs and saying what the jurors are thinking. And, you know, that email was shared with the court. The court shared it with us, but as part of the email, when you look at it, she's talking about juror number 1 shaking his head hostilely towards the defense witnesses, that Jules is calling into the talk show saying
that's
that
what she observed.
that they're hostile to all of the defense witnesses.
What are you talking about?
You get to what I think is very glaring was the October 26 questions when Sally Smith's video was played. I'm sorry, when Sally Smith took the stand. If you look at what juror number 1's wife is posting online at that point, and she is, you know, again, I don't need to establish the pro-plaintiff bias, but it's concerning to the defense that when you look at her social media follows, it's not just the pro-plaintiff blogs. It's the Take Care of Maya producer. It's Mr. Anderson's jury consultant. And she writes on October 27th, I think Sally Smith only relied on Tampa General to decide this case. At the same time, her husband's asking the same questions that Your Honor may remember Mr. Anderson was complaining to the court. We need to clarify that the 2015 Bonnie Rice call was different than the 2016. When you look at his questions, they are, quote, why would Dr. Rice, a TGH doctor, need to call you, Sally Smith, about Maya when you're over at ACH? And then he asks the second question, why is Bonnie Rice calling you to raise the red flag? They're sharing the same questions and the same concern and the same confusion. You know, again, when you fast forward.
Juror
From a
1 and his
timing
wife may in
perspective,
fact
didn't
think in
juror
similar
1
ways.
ask the question first, and then there were comments from, I don't know what to call it, the public, you know, trying to discern what the question meant.
They were made at the same time, yes, Your Honor.
No, which one was first?
I believe his questions were first.
So assume that the statement was from somebody other than the wife. If someone sitting in the gallery observes a question and then comments in a public forum about the meaning of it or the questioning of it, how does that show inside information with the juror?
Because it's a discrete issue of sincere confusion that they both share on the same topic.
What?
And, you know, again, under the totality of the circumstances, as the defense is looking at this,
We
in
all had
retrospect,
similar thoughts.
What
are you talking about?
Belies credibility that the two
You're
of
acting
them
like
share
this
the
is
same
some sort of
confusion
hyper unique
on the same
observation.
topic with absolutely no
So
communication.
we can say it must
And,
be
you know,
the same.
because of the time
It's
limitation.
like, hey,
I just
maybe
want to
they're
fast forward
confused
to the
about
part
how
that
much to pay.
I really think is concerning. You know, we filed the video of the court of juror number 1's wife sitting next to Jules in the courtroom.
Notorious.
Again, this justice system requires not just obviously that the jurors be sequestered from outside information, but it requires the appearance that everybody participating in this tribunal is fair and impartial. I find it impossible to believe that, and I'll say it, that the Kowalskis didn't know at that point, because Jules is texting with him and communicating with him, that she didn't just spend the day with juror number 1's wife. and that when we made the motion to disqualify juror number 1 for our feeling that he was no longer fair, that he was no longer impartial, somebody has a duty to let the defense and the court know, hey, by the way, his wife was in the courtroom. She's posting online saying, my new best friend is Jules. She's posting in chat rooms saying to one of the bloggers, check out the burner phone with regard to information we have about the Heart Institute. And they're making plans to go to dinner. I mean, at some point, just
Juror
the
one's wife isn't allowed to go to dinner with Jules?
The foreman of the jury's wife sitting in close contact with the agent of the Kowalskis is wrong.
The agent.
And the idea that this
Agent
can go
Jules.
on, unbeknownst to the defense and known to the plaintiff, that ultimately culminates in a motion that we brought in, I believe, November 6th, asking for the disqualification of juror number 1. And Mr. Anderson, as you remember, went back and forth on it. I think I have to agree with this. You asked him, in fairness, Your Honor, do you want this as an appellate issue? And Mr. Anderson said, no, I'm going to substitute in the next juror. And then he went to Mr. Kowalski and said, they had a conversation. Obviously, we're not privy to what the conversation. He said, based on the conversation I had with my client, I have to go with his wishes.
I'd be
and keep
literally
him on.
face palming as the judge right about now. I'm telling you what.
At that point, we believe,
I'm not sure I would have had the hearing.
It has to be clear that they
can
knew
decide this on
that
the
his
papers.
wife was in the gallery. What Jules may have told them about what conversations she had, we don't know. But we're
Oh, no,
entitled
my
to an
God.
interview
Jules
on
might have had a
this
conversation
subject to
with the
find out.
wife.
Well, let me ask you this. Assume for the sake of argument, I agree with you that from an appearance standpoint, or maybe the cumulative nature of the instances that you have laid out, suggests we need to have an interview. What type of parameters would you recommend be for that interview?
Right. And Your Honor, honestly, I've never had to make this request in my 20 years as a trial lawyer. I will say I understand that
This wasn't the time.
what we're asking for and the consequences of this. I completely understand the need to respect the judicial process and the jury process and not pry into their lives. I've never
what
called
do you
a
wanna
juror.
do?
Obviously, that would be improper and illegal. Their deliberations are theirs, but in a situation like this, with the totality of what's going on, we obviously need not just an interview to see who said what to whom.
Invoke
the problem
privilege till
is-
you die.
Either one of them could just frankly
Invoke
say,
marital
well, we didn't
privilege till
talk,
you
and that
die.
can't
That's
be
what
the
I
end of
say.
the inquiry. I would like to know, since juror number 1's wife and Jules were in close contact,
Notorious.
apparently new best friends, texting about the trial, talking about burner phones. I'd like to know what the communications were. And
Did they say boyfriends?
Again, I know it's a big request, but we'd like to know what text messages were going on between them. If the court
Jules,
wants
were you
to
talking
view them
about
first,
boyfriends with the wife of juror
you know,
1?
look at them and decide, is there anything there? And you can tell us. I don't know any other way to do this, because otherwise, I mean, he at least according
You
to
still haven't
his
answered the
own
question, by the way.
social media posts, he's been in contact with Mr. Anderson, who's told them not to say anything.
You still haven't
So
answered the
he's
question.
lawyered up to that
How do you want to
extent.
do
He's
it?
going to be, I'm not suggesting the plaintiff's counsel would ever say to him anything other than tell the truth. I'm not. But, he's been lawyered up at this point and advised multiple times that if you say the wrong thing, you're going to throw out this verdict. So I don't know that we can just rest on the assumption that if the court were to ask a series of questions, did you consider any outside influences? Did you hear anything? If we get frank denials at that point,
Objection,
that would
non-answer, I
satisfy the
agree.
inquiry. In this age of social media where people are, where
Oh,
our
not
primary
boyfriend?
concerns
Oh,
came
okay.
from social media, we believe that the proper remedy would be some type of inspection of electronic devices to see if communications were made between him and his wife regarding the trial, to see if communications were made between his wife and Jules or other agents of the Kowalskis, and to see what they're talking about. Because of course, if there's a text message that's going on between, for example, juror number 1's wife and Jules, that says, don't worry about this, he's going to vote for you, that would be
Jules
massive, and
lives
that
in
would
his
be
head
grounds for
rent-free,
new trial.
bad.
So our request for
Damn.
this would be the interview. We would certainly defer to the court to the grounds. We're not looking, we suggest it would have to be on the record with people with the chance to examine it, but we believe there has to be some type of an inspection, and the court can certainly control it. We could draft what we would propose as an order if the court were inclined, and I would respectfully suggest that we've more than satisfied our burden under
You're
Rule
not even remotely close to
1.431,
anything resembling your
with the
burden.
my sworn affidavit, with the evidence we put forth here and more. And I would suggest that I would get with my appellate counsel, Mr. Altenburn and Mr. Hunter, and draft a proposed order that would encompass what we believe would be the scope that would include not just an interview, but some type of an inspection of electronic devices.
Yeah, you want to get their phones.
Thank you, Mr.
You want
Shapiro.
to get through their
From
phones. You want to do a data dump of their phones and their emails and all that stuff. That sounds great.
Please support, we'd like to write up some.
Could you please approach the podium, sir?
I was there.
I can't hear you.
The legal arguments.
Damn it.
Would be handled by Mr. Elliott.
I'm going to try to keep us to one attorney per issue.
Oh, he looks like he's
So-
approaching the
If you
podium.
send support, then
If I've got questions, I know how to ask. So, Mr. Elliott, let me just start. Isn't what the defense has put forward in their motions enough for us, from a appearance of impropriety standpoint, to go ahead and have a juror interview
The judge is actually
some-
considering this. I'm amazed.
with some parameters to be discussed? I mean,
Or if he's
isn't
just
that
given an
what
opportunity to
really
knock it out of the
we
park.
have to do at this point?
Your Honor, we would say no.
Why?
Several things. First off, and they've got several different components here, but all the stuff that's in the original motion is supposition.
I hope he's
attack
just
by
trying to
proxy.
appear fair.
They must have done this. They must
Well, I
have done
wouldn't even
that.
try, to be honest.
This thing was live. This thing was on live the entire time. Everybody saw what was going on. They're assuming things that they can't prove, as we point out in our response. As we also point out at the very beginning, they waived all of that because it was all available for them to see. We know from what we've submitted to the court, Mr. Shapiro was online. We know his wife was extensively online. So if we're going to assume that wives and husbands talk, which is what they want you to do for the juror who was told not to talk with his wife, we have to assume Mr. Shapiro and his wife were talking, and he knew all of this stuff in real time that was going on, and they do nothing about it until after they get an adverse verdict.
Nice.
So all the stuff in the first one, I would say, is gone on that basis. And then we go through each of them and tell you and explain why. For example, the creature comforts, that was, contrary to what they represent, that was said before the question was asked. It's also a very common phrase, as we point out. So each one of these things has a logical explanation. You can't put together 15 things, if that's what there are, that have no significance and say, oh, now we've got a big conspiracy.
You got 15 things
So
that are
that's why I
pile of
was saying,
stupid.
first
That's what
motion,
you got.
gone
You got
because of
15
that.
things that are meaningless, and you
The-
put them into a group. You got a pile of stupid.
The second one, with regard to the 2002 notice, over 20 years old, case law is very clear. That's way beyond the time to be relevant to anything. You also can't tell anything that went on from it.
I mean, what if, and I guess it's just a what if. What if it involved, I think it was probably HRS at the time and not DCF, but
Right.
HRS at the time. And he being juror one, harbored some view of HRS that
We could do a big pile of stupid coffee mug. That might be
we
a good
brought
idea.
forward. Isn't that something that the defense would have been entitled to know about?
Your Honor, we don't.
Why would we have asked the question in the first place on the questionnaire if that wasn't something that we were concerned about?
Your Honor, from what they've submitted to the court, they haven't gotten to the threshold issue of showing anything that went on. I mean, we don't know if he was the complainant or maybe it was the subject of it, but we don't know anything about what was involved there. There's just no background. Plus, it's over 20 years old. Case law, we've cited some cases where things were much less time than that, and the court said that's not material at that point. It's too old to be material. Of course, this is not a case against DCF. If he harbored something against DCF or HRS, maybe his ire would have been directed toward them and not the hospital. It might have been good for them. So, this is all an after the fact, trying to get out of what happened. That's what this is all about. The juror two supplement on the writing of the lettering, I think the court has dealt with that. I
would use much harsher language here as an attorney at this point. I'm telling you what. Be like,
But
this
if we're
is
talking about
absolutely
using the
atrocious.
letters, I have a demonstrative exhibit.
I guess album.
Okay,
Nice.
these letters are commonly used for a long time. Okay, it does not mean it's a Nazi symbol. From what I've read online, 2 of the founding members are Jewish in this group. So
Nice.
I think that should dispose of that. Then we got a new one this morning. We've seen, this is the first time that we've seen this. First time we've seen this. It does not, from what we can tell from here, and there's no follow-up, there's no, here's a conviction, here was a prosecution, nothing like that. So we don't know if there was any kind of conviction on this.
What are we talking about?
We're talking about this affidavit you got this morning about
This morning.
a threat by apparently.
We're gonna have to do another. We're gonna have to do
Drew, one's
another
wife,
document review
before they were married. It was before they were married. It's a threat by her son.
Someone please
Stepson.
post this new exciting document to my Discord. We'll discuss it after the hearing.
First time we've seen this. It does not show, there's no follow-up. There's not showing of any conviction. There's not showing of any physical harm, any physical crime being committed here. This is, again, just a lot of grasping. It's, again, trying to attack by proxy. Who knew who in the courtroom? Really? I mean, if this goes where they want it to go, you're not going to have any more married jurors because there's going to be a presumption. Every juror speaks with his or her spouse. So that's just too much reaching. As far as the materiality goes, they said, well, they didn't disclose, so we've met that. No. To your point, Your Honor, they have to show it was material. It's a 3-part test. Even if there was a blatant concealment, there has to be material. And when you don't ask any of the others, and they can't come in here and tell you, oh yeah, we asked everybody that listed this, we asked them. They haven't gone back, they haven't even done that exercise, I think because they know it wouldn't support their view.
Great
But
chat.
What really happened here is they didn't ask juror number 1 anything because he had a law enforcement background. They were happy to have a law enforcement person on the jury. They're generally conservative. They liked him until, I guess they didn't like some of his questions as things went along. We had the earlier motion, which was properly denied. So I'm happy to try to answer any of the questions, but we don't think there's enough here to do anything.
Well, assume for the sake of argument that I feel that there's a need for a juror interview. So
Okay.
make that assumption.
All right.
What is the scope? What are the contours for that interview?
I think it would be clear that you would conduct it, Your Honor. First off, we're not talking about a deposition. We're talking about the court conducting an interview. When I've been through this before, that is the way it has always been done. You don't let one side or the other have their way with a juror in a deposition setting. So you would conduct any discussion like that. It would have to be very limited. I mean, this business about, I want to get into all the texts and all the stuff.
Invoke privilege.
That would be unprecedented.
Invoke all the
Every
privilege.
time after this, there's an adverse verdict. You're going to hear people saying, well,
Don't.
okay, I want to get that juror's
Invoke
text
all
with his
the
spouse or his cousin or his best friend or whatever. I mean, where are we going to go with this?
Marital privilege is looking real
I
good
guess
right about now.
And I think you do. You ask these jurors every time when they came back, every time, have they followed your instructions? Have they not discussed the case every morning? They all said yes. I mean, I don't see why an interview would be any different on that. I mean, but that would sort of be the scope of it. I mean, I don't think it's clear you cannot, that no one, the court nor us, can delve into the jury deliberation process. At least,
I mean, I guess I'm with you on the thought process is probably something that we don't or shouldn't go into. But if we're talking about a alleged violation of the court's instructions, that's kind of extrinsic to the thought process. It's, did he receive information outside of the courtroom? And isn't that something that we should know about?
and he's already told you he did not, repeatedly.
Yeah, that's true. He did
I
say it every
suspect
day.
if you ask him again, he'll say the same thing. And they're probably right about that, but I don't think that gives anybody carte blanche to go delve into everybody's personal information. I mean, again, all the things that they talk about in their first motion, which would lead to the interview, that they claim should lead to the interview, are all things that were publicly known. They are charged with knowledge of that. It was on the internet, all those things. They saw who was sitting in the courtroom. They saw this person and they saw the juror's wife. They saw them sitting here. Okay?
Well, to be fair, did they know who that person was at the time?
I think they knew who Jules was. That's pretty clear. And it's pretty clear from Mr. Shapiro's wife's posts. They knew that. And I have to assume Mr. Shapiro and his wife were talking.
Fair.
Okay. Anything else, Mr. Elliott?
Not unless you have any further questions.
Well, let's talk more about the scope and contours of the juror interview if we were to have one. So you're suggesting that the court is the one asking the questions?
Unquestionably, Your Honor. I've been through two of these before, and that's the way it was always done.
And I'm assuming here in open court?
That was not how it was done before. It was done in chambers with counsel present. I mean, you still have a juror anonymity issue, I think. But I haven't researched that. I haven't, I'm just saying how it was done before.
My recollection from the papers is the defense have put forth that juror number one has identified himself publicly as juror number one.
Well, I think they outed him first, Your Honor, but I don't know which came first.
Okay, and so the court were to conduct it, and what are the limits?
I think you can add, I think it would be limited. I think you would say there have been allegations made that you were communicating during the trial information that,
I declined
that you were
to answer
discussing
on
it
the
when I
basis
told
of
you not
marital
to.
privilege.
Is that true?
That would
Anything
be
else, Mr. Elliott,
I
you wanna
declined to answer on the basis
tell me?
of marital privilege.
I don't think so at this time. I don't have any further questions.
I don't have any further questions for you.
Okay.
Any very short rebuttal, Mr. Shapiro?
Any questions for me, Your Honor, in light of what?
Much like the right to remain
sorry, no, I
silent,
don't
it's
have
a
any
good
questions
idea
for
to
you, Mr.
invoke your
Anderson.
rights.
Now, I don't know yet what I'm going to do. I
Really?
intend on resolving whether we're going to have a juror interview
Are you really considering this?
sometime next week. So I will do my best to get an order
Really?
out. But for now, if, this is not saying
seriously
we are,
considering
but
this?
if we're going to have a juror interview, let's talk about when it will be. I think I put in the prior notice that it would be the week of January 2nd. So, what about January 3rd? It's a Wednesday. Would the attorneys be available on January 3rd?
Judge, we would still be out of town until hang on 1 second. I could appear by Zoom for that.
The defense can make themselves available.
On the 3rd?
Yes, sir. Yes.
Mr. Elliott?
Yes, Your Honor.
Mr. Altenburn? Okay. It will if we have one, it most likely would be on January 3rd. I don't know what time. We'll figure that out if we're going to have one. So let's move on to the next topic on our agenda, which is the topic of a renewed motion for basic JNOV. Renewed motion for directed verdict, notwithstanding the verdict or whatever it's now called.
Now called. I still think of it as a
JNOV.
JNOV myself. And I'll point out, you've divided my very long motion into 3 parts of 15 minutes, and I could spend much more time than that, so I'm going to have to just identify fairly specific things that I think are most important that I would like to
We're gonna
address.
be here a while.
In this first section, I
And
want
They're
to,
gonna
I've
need a
read-
subpoena.
I've read
Unknown. They're going to need a subpoena.
everything. I mean, I didn't read this affidavit
And
yet.
if it
but I
were
will.
me, I would strongly
and so I want to
consider
focus on the
filing a
motion for
to
directed
quash
verdict
the
as to the
subpoena
intentional
on the
infliction of emotional
basis that I
distress
won't testify due to
resulting
marital
in
privilege
suicide
That would be what I would
Briefly
do.
discuss the insurance fraud motion for directed verdict, and finally the motion for directed verdict as to the punitive damages claims against the hospital. On the intentional infliction of emotional distress causing suicide, I mean, it's now, you clearly understand that this has to be
And
extreme
as always, by the
outrageous
way, this is
conduct
not
that's
dependent
atrocious to
on
the
whether or
point
not
that
you
it's
have
no
something to
longer
hide.
acceptable or cannot be acceptable
Much
in-
like the right
in a
to remain
civilized
silent.
community.
You always invoke
plaintiff
the right to
admits
remain
that
silent.
no
I don't
one
care if you
event
have something to hide or not.
Was enough to trigger
It doesn't
that
make you look
standard
more
here,
guilty
and
by
is
invoking your
wanting to use a
rights.
series of
Everything you
things.
say can and will
And
be
now
used
is
against
claiming,
you.
although it
Keep
seemed
your
to me
mouth
during the
shut.
trial and otherwise that there-
That would be
that the-
what my
there was
recommendation
no
would be, basically
conspiracy or
universally.
group
If
of
you
people
can stand on
planning this
privilege,
at the
it's
hospital. It felt
probably
that
a
way
really
at
good
the time.
idea
Now
to
they're
do
just saying
that.
it was random people in the hospital that did these things that rise to the level that when communicated by her husband to her, caused her to commit suicide.
Nate's lawyer gives $10. Thanks, Nate.
The first thing I want to argue is that my first jury instruction proposal to you was the correct standard, that a common law court expanding incrementally the common law should restrict this claim to one in which the intentional infliction is done for the purpose of causing suicide. And if that were the standard, we wouldn't have even had a trial here at all on this. And respectfully, if we are to go beyond that public policy to something where something that's even a substantial factor ends up being a matter that causes 100% responsibility under an intentional tort, where we can't claim that she was comparatively negligent, we can't claim that we're entitled to contribution from DCF or anyone else. If that's to be the law, that should be the legislature that does that. That's a step beyond what a common law court should do. So I'm asking first and foremost for a directed verdict because that was a standard that should have been done here.
What?
Now, if you reject that, then we go on to how we actually tried this case. And what I have pushed repeatedly is to, because the pleadings were never a plain and simple statement that said, on this day, this happened and it was extremely and outrageous conduct. And on this day, this happened and it was extreme and outrageous conduct. Instead, they tell their story with lots of adverbs. And so the question has always been, well, what are these things? What is it that's so important that it causes this to be intentional infliction? And in their response on page 84 and 85, they say that the defendants ignored Beata's request to have Beatty removed from Maya's care. Well, that was the negligent supervision and negligent retention claim. You're quite familiar with what the evidence on that was. There's nothing in there that rises to extreme and outrageous conduct at all. She was the most experienced person with DCF cases, and we kept her on this because it was a complicated DCF case. That's not something that's not tolerated in the civilized community. The next one is then that we allowed Ms. Beatty to molest Maya in the chapel. Now, we've been through that multiple times, and you know that that's not the evidence. You didn't even allow punitive damages on that, let alone to go to the jury on this. So that's not proven. It's a distortion of the evidence, and it's certainly what is proven that didn't even allow for punitive damages is not enough for this count. Third, they say we refuse to allow court-ordered visitations by phone and FaceTime. Isolating not.
Let me ask you, because on punitive damages, there has to be that next step of, upper management, knowing, ratifying, whatever the statute says.
Correct.
Are you suggesting that the punitive damage standard is engrafted onto the intentional infliction of emotional distress cause of action?
What I'm suggesting is the Supreme Court has said that it's not enough for it to be punitive damage level. It needs to be more than that to constitute intentional infliction of emotional distress. That's from the very first case discussing this that they've said that. We've said that repeatedly.
But what I'm saying is, so you're saying that there has to be a upper management individual either directing or condoning, ratifying the specific conduct as opposed to someone who's not as high on the food chain doing it.
I don't know that I'm necessarily saying that, but what I'm saying is that the testimony from Maya about what went on in the chapel was not molestation. It was she put me on her lap and she hugged me and I didn't want to be hugged. That's not molestation, and that's not conduct in that context that's extreme and beyond what a civilized community
That's
expects.
battery.
She may have been unwanted affection, but it is not enough for this tort. And the next one, when they say that we refused visitation by phone and FaceTime, you heard various times when they were on court-ordered visitation. You've heard how complicated it was for us to try to comply with the Chapter 39 requirements on this. And as
Why?
to FaceTime, they're flat out wrong about this. They've made claims that after December, I think it's 28th, that we didn't do this. But if you look in the record at Exhibit 1001, pages 1985, 1982, 1981, 1787, or in their exhibit 2277-628,
2277-628.
you will see multiple records discussing the difficulties we were having and that these things were taking place. That in fact, we have the one from page 1985 shows that these are taking place on January 3rd. They took place twice on January 3rd. There was one on January 5th, the day before she committed suicide, that are all in the documents. And the earlier documents show that at the very beginning of this, in December 31, they're fighting about, well, is it 1 hour's worth of time or a half an hour's worth of time that she gets in these? And she wants it moved from one time to another time, and they're trying to accommodate her with that, and they're working with DCF on that with the social workers. So there's all kinds of evidence that shows that the FaceTime stuff was going on in that time period, and there's no testimony I can find from Mr. Kowalski or anyone else that says that's not the case. One of these says that Mr. Kowalski himself was present for one of those calls, that he was in the hospital and that her mother was at home. So there is all kinds of evidence on that. Then we have that we refused to facilitate family therapy sessions ordered by the dependency court. Now, you will recall that the judge in the dependency court sometimes didn't get his orders very clear. We had to actually clean up a couple of things. But one of them was, he said she couldn't be in the hospital. And then later on, there was this spot that said, well, the family can attend therapy sessions. It was an ambiguity in the order. If it was to be cleaned up, it was to be cleaned up by the judge in the dependency proceeding. They never asked for that. The fact that we
was
didn't
an
honor
ambiguity in the
this
order is
is
what you're
not
going
something
with?
that is extreme and outrageous conduct on our part. It just doesn't come close to that. And finally, they say we ignored Beata's medical decision-making rights that had been preserved for the dependency court and tormented Beata further by threatening to remove Maya's port. I'm sorry, going to the port, we suggested it would be a good idea. I think Sally Smith did the same. And Beata refused to have it taken out. That's all there was to that. No one was threatening her with anything with that. As to the medical decision rights, she did retain certain medical decision rights, including the one not to take out that port. But she also was in a DCF proceeding that was accusing her of medical child abuse because of the
Accusing
treatment,
is not
including
the
the
same thing, my
ketamine that she
friend.
was doing. So the notion that she had a right to say, I'm going to do whatever I want, even though there's a DCF proceeding going on, that we should
You
be
do have
compelled
the
to
right to do
that
whatever you want while the
as
DCF
something that no
proceeding is
one would
ongoing.
not honor in a civilized community. That is absurd.
Yeah, your
So
rights
the
aren't
things
taken
that
away
they
till they're
have
taken
listed
away.
here
What are you talking
don't
about?
fit that. I could go on with the rest of them, but I'm going to run out of time. They were things like we didn't.
Hey, Babs, nice to
we
have you
wanted
here.
an open door when her male lawyer came to the hospital without anyone else, and he wanted to be in the room with her alone. There's a laundry list of things that they say this way, that we negligently changed her diagnosis from CRPS to something else. And the last
I
thing
think
that
that's
they
the
talk
least of your
about
problems.
is that,
The change the diagnosis.
they talk about that we
You can't retry the
intimidated
case.
her because of all the things
You can't retry the
that occurred on
case.
January 6th, none of which she knew about. That is undisputed. So these things,
But they're going to try
even if
anyway.
you're looking at Maya, it may not be enough for intentional infliction, but what they're claiming is that these things when communicated by Maya in some fashion, we don't know the details, to Jack, who took them home and told them to his wife, got her so upset that Jack didn't come back and tell the hospital about it. Jack wasn't even concerned on the day she committed suicide that she would commit suicide. But we were supposed to have foreseeability to know that what our people were doing, not as a conspiracy, but in this random approach, was enough that we caused her suicide. And I am sorry, that is just not the common law of the state of Florida. We are entitled to a directed verdict on that. We were entitled to a summary judgment on that claim. That is simply not something that they have proven here. Now, as to the fraud insurance, it's a small claim, but it was a claim of intentional fraud. And that is in terms of what the jury was told that there was a fact question about whether we intentionally defrauded them with the insurance. Now, I put in recently just the testimony from Mr. Kowalski about the insurance. There's just a few pages of that. And you know that they didn't actually even put in the bills to begin with. They put in the 3 years of medical processing by Aetna. They never called anyone from Aetna to say there was anything improper about the billing. So they're not charging a breach of contract, but even if a breach of contract were the issue, they'd have to prove up what their damages were. And so here they're claiming that somebody in our billing department put a number on a bill with the intention of defrauding somehow Mr. Kowalski or the insurance company, when the insurance company is not claiming to be defrauded. And that person knew that it was a false statement to defraud them, even though if you look at the medical records, we were providing physical therapy, occupational therapy, cognitive therapy. They're complaining we didn't do enough cognitive therapy, but those are all things that would be done for CRPS as one of the options of a diagnosis.
Or conversion therapy.
When you go beyond that, and he says, well, it's because I didn't pay a copay. He presented no proof, and he admits in his testimony he has no proof of that. He has no proof we sent him a bill for a copay. The statute of limitations for trying to enforce it by a lawsuit has long since expired. There's no evidence of that. There's no evidence that the deductible was somehow spent on this as compared to everything else that was paid. Those bills were predominantly for 100 days of service in that hospital that we were required to do because the court wouldn't let her out of our hospital. So those things are simply not proven here. As to the extra insurance costs, the only thing he ever did was say that his COBRA bill was higher. Well, that's because his wife no longer had group insurance. It has nothing to do with anything on the coding of a bill from us. So we're entitled to a directed verdict on that claim. Now, finally, on the individual claims for punitive damages, I'm going to start with, I've got limited time, so I'm just going to aim first at the first week. In that first week, and I'm looking at the first stage of the punitive damages. You heard the doctors, what condition she was in. There's no dispute the first day she was in tremendous pain. She was sent there by her doctor, and they began treating her in the emergency room and in the PICU and doing things that they believed were in her best interests. As Dr. Elliott explained, he was doing things pharmaceutically with her that he believed if he put her out the door because the parents wanted her out the door, it would be dangerous.
You know, I can't help noticing that
now maybe he's right.
the vast
maybe he's
majority
wrong.
of the things he's
But
saying
for punitive
are questions
damages,
of fact.
you know, the first front end is, was it unreasonable and unwarranted not to send her home with mom? Keep in mind that mom's email, which is the email on
There's a whole bunch of facts that help us.
October 12th, where she explains that she had this interview the day before with Dr. Smith. So she knows by then that Dr. Smith, by the way, is not one of our agents. But in that, she's explaining that she didn't want to take her home, that she was really trying to get her to go see Dr. Hanna, that she needed to have her in an ambulance to go see Dr. Hanna. So for a chunk of this time, she's not really false imprisoned, but one way or the other, the test is from an intentional misconduct, is whether we had actual knowledge of the wrongfulness of their conduct and the high probability that injury or damage to Maya Kowalski would result and despite that knowledge, intentionally pursued the course of conduct resulting in injury or damage to Maya Kowalski. Now, there is no evidence that the doctors in the emergency room or in the PICU fit that standard. You heard from all of them, they don't fit that standard, without even getting to the fact that the level of management above this knows about this front end, from the evidence at least, they're relying upon the fact that these doctors are on committees for the hospital for management there. They're entitled to a directed verdict on this one. It's the same as to the EEG room and as to the photographs at the end when you look through those things. Under the evidence and the law on this, they're
Kind
entitled
of
to a
like an
directed
appeal.
verdict. Now, I've got a
It's sort of
reserved
like an appeal.
motion
It's
for
an appeal
directed
before
verdict
the trial
on
court.
the issue of specific
Yeah,
intent.
kind of what they're doing. They're kind of
I'm hoping
doing an
that
appeal
I'll
before
try
the
to do
trial
that in the
court.
damages part.
It's not going
I'm
well.
completely out of time here. Thank you.
From the plaintiffs.
Hey, trial court, would you like to overturn yourself? Also, a lot of these things look suspiciously like facts. Would you like to ignore the fact that the jury,
Would like me to
sat?
start with.
I think the one that Mr. Altenburn was hitting the most is that the conduct that was discussed at trial did not rise to intentional infliction of emotional distress relative to the Beata Kowalski suicide.
Okay, let's start with that.
I mean, I don't think you need to go to the wrong standard. That issue, I've
You've ruled on that.
addressed and ruled on.
You gave them two different options. Okay. And
Well, I think Mr. Altenburn first wanted me to come to the conclusion that the hospital had to specifically intend to cause Beata Kowalski to commit suicide. I think that is where I think Mr. Altenburn wants me to go. That particular issue, I don't think we need to address, but his next argument about the quality of the evidence is
Specifically
insufficient.
intent is an interesting idea.
It is sufficient. And
How so?
what you
That might
heard
work
is you
on
heard
appeal if Johns
talk about
Hopkins
one little
get
thing here,
their
one little
head
thing
out of
here.
their ass.
Pages 2 to 5 of our response, we list many, many things that the hospital, using that generically for a moment, did over time
Nice kid.
to Maya Kowalski and her family, and of course that impacted Beata Kowalski. We do not say that there was not one event that caused the suicide. I don't think we say that. If there was one event, we do think it was a series of things. There were a series of things that led to this. The one event might be the photo taking. And if you look, they make a statement in their memo, and I'm not sure we corrected this, that Beata didn't know about the January 6th photo session. Well, that's contrary to Jack Kowalski's testimony on October 3rd at page 138. He says he told her about the videotaping, told her about the photos. So he testifies to that. That's in the record, and the jury's, we get to assume that the jury believed that. Okay, so she was told about that. We're talking here about the mental and physical torture of a 10-year-old girl for 3 months. This goes on over a long period of time.
Launch crimes chat
To say,
seems to
the
be
doctors, when she
swinging a
first
little
came
bit
in,
more
they
in
weren't
favor
doing
of
anything
Johns
bad.
Hopkins,
Risk
incidentally.
management was involved from day one. You can see that in the medical records. Risk management, as Beatty testified, instructed her to do these things, instructed her to videotape, instructed her to take the pictures, okay? And we have a detailed discussion in our memo about...
The videotaping and the pictures occurred after the first week in the first
Right.
claim
Yes.
of false imprisonment.
Right, but during that first week, it's not just a few doctors at the beginning. The risk management is involved from the beginning in this case. As I said, we list the events that went on. It was, as you laid out, 3 periods of time. It stayed to that. I'm not going to try to go through all those things. They're in the memo. We've addressed them. And when risk management is involved, that is the hospital. Okay, I know they want to say we staffed it with lower level people, but in evidence. Oops. Under 2802, Exhibit 20, there is a chart of the makeup of the hospital. This is in the record. We've got some extra copies if you or the council would like one. But you see above risk management, immediately above that is senior counsel Crane. Okay, so risk management is under the auspices or reports to Crane. Right above her, she then goes directly to the chief executive officer of the hospital. Okay, so as we point out in it's about a 5-page discussion in the memo, Florida law and federal law and the Joint Commission that they voluntarily agreed to require that the hospital be responsible for everything that happens there, everything. Okay, we're not talking about just supervision, we're not talking about just training. They're responsible for it. It goes up the line. Okay, and this chart shows how they were reporting up the line. So they are charged with the knowledge of that. That committee, risk management, under the senior counsel Crane, is directing these things be done: picture taking, videotaping. They could have brought her in to testify. Oh no, that didn't happen. They were rogue. They didn't do that. And quite frankly, even if they had done that, they're still responsible. If you work through the analysis there, they are responsible for what happened. So if they weren't doing what they were supposed to do in terms of letting people know what was going on, that's liability of the hospital. And when we get to the punitive damage part, they're either under A and B for approving, ratifying, etc., or they're under C for the gross negligence and not knowing what's going on. So either way, they're going to be liable there. And it sounded to me like the intentional infliction was blending over a little bit into the punitive damages. But if for either one of those, the hospital and the higher up people either knew or they are deemed to know under the law. So the intentional infliction, the items that went on, we say were sufficient. You've ruled that before. The jury obviously found it sufficient. We don't think this is a matter of law to be removed from what the jury did. If there are any other questions on that, I'm okay.
Yes, sir.
On the billing fraud, they listed hundreds of times that they were billing for CRPS. I still don't know that I've ever heard them say, yes, we acknowledge she had CRPS. I don't know that they ever said that, did they? I mean, I know you asked them about it. I don't know that you ever got a direct answer to that. They seem to want to walk the line on that. When you bill for something that you're not doing, that's fraud. Now, did it cause any damage? Did it cause any damage? That's why in the closing, the request for nominal damages, because of all the other things going on here, there could have been a person who would come in and testify about this, this was too much, this would have been that much. They didn't put one on either. Okay, so that's why we suggest that a nominal damage is appropriate there. Let me flip back. One thing I forgot to mention, and I even had it tabbed, that the jury did hear. We talk about where's the evidence that they, and again, we don't think they had to intend the suicide, as you ruled, but where's the evidence that they were so callous and so forth? How about Trial Exhibit 2175-004 from the text messages of Dr. Voss? Learned today that Ketamine Girl's mom committed suicide yesterday. Sorry to say my prediction was correct.
Yeah. Yeah.
You have a medical staff member predicting the death of a mother of a patient there. And why didn't they do something about it? Okay. Does the court have any other questions on anything else on the DV?
No.
Then I think I'm done. If anybody wants, you have access to this chart.
He's
I know.
got it. He
It's-
knows he's got
It's in the
it.
file.
Yes, I know. Thank you, Your Honor.
So this is
Any
a
very
little
brief
bit.
response, Mr. Altenburn?
What would you say?
First of all, with respect to Mr. Elliott, I think he must be confusing.
This whole thing is a little pro forma.
Mr. Kowalski could have said about the videotaping in October with what happened on January 6th. There was no evidence. It was very clear at the end of this case that she had no knowledge of the photographs that were taken the day before she committed suicide. Maya didn't talk to anyone about them, and they were back in a storage closet, still in a camera at that point in time. There's no knowledge of them. As to Dr. Voss, we've been through this. You heard her testimony. This is, first of all, it itself is not extreme and outrageous conduct. It's after she's dead. And it's a text message type discussion between two doctors. And she has explained, there's nothing that she reported or put in the medical records about this. The medical records show that mom was suicidal or expressed that she wanted to go to heaven, I think, that day, or maybe that Maya did, and that the people at the hospital offered to help her with assistance to get help from someone else, which she declined. That's all that's in those records. And as Dr. Voss explained, she was saying prediction was maybe a bad choice, but what she was saying that she had thought about this because she knew about something like this 20 years before when she was a resident. Respectfully, I've never thought that that was relevant to much of anything, and the prejudicial effect of it is far more out there than the probative value of it as to that particular claim. As far as the things at the beginning of their response, I invite you to go through those and take a look how many are negligent things, how many are things that you can look at and say are not accurate parts of the record. They don't support it any more than the ones they specifically used when they were addressing the particular one. There's no evidence on that in this case. Now,
I'm sorry.
go ahead. I'm sorry.
Yeah, were you finished with your rebuttal? Because we're then going to move
Please
to the
finish.
next topic, and I'm assuming you're
I'm standing here ready.
okay. So what we're going to do is we're going to do the next topic, which is the motion for new trial, which is exclusive of the alleged juror misconduct issue. After we do that, we will take a morning break.
Good.
Okay. So Mr. Altenburn, you have the floor.
And I'll try to be shorter on this one. I want to save a little more time for the damages part because it's complicated. But on the motions for new trial, obviously on intentional infliction of emotional distress causing suicide, my argument would be if you saw some tiny amount of that, there's still the manifest weight when you analyze what the law should be on this is that verdict was just off kilter. The fact that it's off kilter on damages on practically every line kind of demonstrates that this jury was involved with a prejudicial effect and various things that got them to go off from the evidence.
Bias is
And
the
so
same thing as
a manifest
judgment.
weight analysis, even if you didn't think it was a directed verdict, would stand on that particular count. I think it also would stand on some of the other counts, and I've argued those to you as well, but I'm not going to take time here today to argue those as well. Certainly, the insurance count, I just don't think there's any evidence there to prove that there was any, the nominal damages were not an element in that, and they needed to prove detriment to the insurance company financially. They never did that. They never brought in anyone to show that that number had any impact on that. So that, if not the directed verdict, ought to be manifest weight. Now, we also moved for new trial because of the Chapter 39 issues, and I do believe that that is important. We wanted a broader immunity.
This issue's already
and
been
that was
decided by the
resolved
Court
on
of
sovereign
Appeals.
immunity, excuse me, on summary judgment ahead of time. So I can't really re-argue that we couldn't get the broader immunity, but I will be arguing that later on.
I'm sure you will. The Court of Appeals asking for them for
here-
reconsideration from your own mistake.
There was a litigation immunity for things that went on in the DCF proceeding that kept out testimony about that. But it got to the point where we couldn't talk about ramifications of that proceeding. I mean, this woman committed suicide
You asked
right
for it to
after
be
a
in. You went to
hearing.
the Court of
We
Appeals
couldn't really
asking
go
about
into
this
the
already. The
details
Court of
of
Appeals
that
is not gonna
hearing,
care.
or the fact that she's upset.
The Supreme Court's not gonna
about
care.
Having a hearing a month from now,
You
that she
asked
may
for
lose
this,
her
ma'am.
child to foster care, it may impact her license, the whole 9 yards. None of those things could we really get into as to the stresses that were on her.
Well, but let me ask you this, because, in the years leading up to the trial, the defense kept saying Chapter 39 immunity, can't. But then at trial, the defense tried to present a lot of stuff that happened in the dependency action. I mean, that's what the defense tried to do.
Yes.
So I mean, I'm trying to understand, it seems like I'm supposed to exclude everything that the hospital wants excluded from the dependency action, but then allow the stuff that from the same dependency action that the hospital wants to use. I mean, how am I supposed to draw that line?
in
And
for
I think I
everybody
kept
or
talking
out
about,
for
you know,
everybody,
This is
man?
where I've been drawing the line.
I know, and
And that line I tried to draw as clearly as I could, but knowing the facts in this case were difficult, I admit.
the line is that no one could rely upon testimony on anybody's part to make someone responsible for something or the like. This is not going to be evidence that could be used to prove liability. What we were trying to explain and repeatedly is that, but on what's going on in Beata's head, why she is upset, why she is truly upset, it's not because of the testimony in there, but the fact that it's ongoing and that they're accusing her of Munchausen's in the proceeding by the state, and the state is accusing her of medical child abuse, and she has hearing after hearing there. She's got lawyers there. All of this is going on, and you know she wants to see her daughter in the courtroom, and they basically have some understanding of that. But when we're on this, who caused her suicide? I'm sorry, but and it was really hard. You know, it's nice to have a jury instruction that says we're not responsible for 100 days, but to try to get the jury to understand all the 100 days of things that are going on unrelated to the hospital that were related to the DCF proceeding. That's what we couldn't get into. And, you know, I know in your head you were having a hard time on that distinction, but those were things we should have been able to talk about, because those were things that were really getting her very, very upset. Those were things that show up in her suicide note. And we should have been able to expound upon those things, and we weren't allowed to do that. And that, to me, is a very important thing. With limited time here, let me move on to two other things. The next one is that with Dr. Smith on the medical negligence, you know, the issue is whether she's an apparent agent.
Oh,
And
Lord.
again, we have the email from Beata Kowalski to herself. It looks like it was going to go to Dr. Hanna, but it never did. It went to her and to her husband.
This evidence
It
was
clearly
presented at trial,
explains that
sir.
she understands exactly who this woman is by the 11th of October. Now, apparent agency is not that complicated. It's a doctrine that says if Joe is negligent and harms me, and I let Joe do something that harmed me because I thought he worked for Chris's Lawn Care,
Thank you for
then
subscribing
Chris's
on
Lawn
Twitch. We
Care
do
is on the
appreciate
hook if
all our
they're
Twitch
the ones that
subscribers. Thank
allowed
you very
that to
much.
take place. It's that he's not a real agent, but the plaintiff relied upon that person and I got hurt. That's the theory. That's the theory when it's the X-ray room that is in the hospital that looks like it's a part of the hospital, but it isn't. Now, Dr. Smith came to the hospital, but before that very first day was over, she knew full well that she was there as the CPT person. Now, they tried to say, well, she can be the CPT person and she can be your agent all at the same time. But, I mean, that makes no sense here. And what they were allowed to do was that they did this and they did that became Dr. Smith in all of her capacities along with the hospital, and we weren't allowed to show even the report that Dr. Smith gave to the court and made available in the hospital on these things. But the evidence had to be that Dr. Smith did something that was treatment that harmed this child. And she may have impacted by convincing DCF to file the proceeding, but, well, she wanted to take the girl off drugs. Well, everybody did. Did that do her any harm other than ketamine?
This argument
No.
isn't working. Thank you very
She
much.
wanted to take out a port,
Sardonisms for subscribing on
which
Twitch. We
Beata
really do
wouldn't let us
appreciate
take
all
out.
our Twitch
I
subscribers.
mean, there's
Thank you
no
so much.
evidence, that after
We now have
October
the B-fish emote
11th
over on
that she
Twitch.
was
I don't know
in
if you
any
guys
way
have
in a
noticed yet,
parent
a
agent.
tier 1.
And B, there's no evidence that she did anything that was negligently
let's see
harmful
some
from that
B-fish on
point
Twitch
forward.
from all of our
So,
subscribers.
other than advising us to
Yeah.
call the hotline, she didn't do anything more
B-fish.
than that. So I don't really understand how we got to this point. And from the way the jury reacted, it clearly impacted them on the medical negligence claim because they interphased the two proceedings, the CPT proceeding and our proceeding. And finally, on count 14C, the negligent training, it should have come out before trial, should have come out at the end of the case, at the end of the plaintiff's case. But what happened, they dropped it down to negligent training, which is not a part of the medical malpractice case. And I told you that that evidence could, there could be some evidence marginally relevant to punitive damages, which I think is true. I don't think there was much of any there, though, because the punitive damages were for not letting, perhaps not processing an against medical advice request to leave the hospital properly. Maybe they weren't adequately trained on that. Dr. Corcoran didn't say a word about that. He didn't have experience in that. Maybe it was because when the doctor sought permission to take the videotape in the EEG room that the little girl would know nothing about, that maybe there was a better process to do that. Maybe there should be more training on that, but that's not what he testified about. What he testified about was the whole structure of the hospital was wrong. Well, that wasn't relative to anything that was alleged.
Well,
in
that was the
medical
IJ,
negligence.
man. That's a pretty
It
good
wasn't
argument.
relevant to the training, I don't think. But it became a big feature of this trial right down to the end when we had all the problems at the end of this case. So the fact that 14C went to trial ended up being very harmful in this case and would warrant a new trial. The last thing I'm going to mention is that I do believe that Dr. Neuberger was allowed to say things that were very harmful in many of these claims. He was a child abuse expert, and he was
Thank
allowed
you,
to talk about
New to UK, for
conspiracies and the
subscribing
like.
on Twitch. We
We
really do
did
appreciate
object
our
to
Twitch
that.
people.
You
Thank you.
overruled the objection. And their argument is that we waived it because we didn't object again. I'm sorry, you don't have to keep objecting over and over again. We did object. You
We're still
ruled on
figuring
it.
out how
They
Twitch
then made
works.
the decision to
But,
play that
we
video
appreciate
to the
everyone
jury,
who's
knowing
helping over
that
there.
if you were wrong in that ruling, that it was going to be prejudicial. They did that, and we're not in a spot where we're obligated to do multiple objections, especially when you remember how hard it was to get anything done between 8:30 and 9:05 every single day. The more we had done that way, the crowd cheer you got, with due respect, Your Honor. So,
There was more than one or two objections during the trial.
yeah. So that's what I have on new trial. Thank you.
You have nothing, sir.
Mr. Elliott.
But thank you.
Thank you, Your Honor. Sort of to start off.
No, I
guess
don't
we'll
think the
go in
judge is going to
order.
rule an interview should take place. The judge would be
Let me
insane.
ask again, anything you want me to particularly address, please let me know as I'm going along. And I'll
No, sir.
do that. Okay. Litigation immunity. And there was a statement about the January 6th hearing, and this is what did it. Well, January 6th was also the day of the photos. And maybe I wasn't clear before. The October 3, 2023 transcript of Jack Kowalski is what I'm referring to. I wasn't saying that he told Beata this in October of 2016. He tells her, did you tell Beata what we just talked about? When I say this, the photographs that had been taken of her, the video that had been taken of her. The witness, yes, I did. I did tell her. That's page 138 of that transcript. So we have direct evidence in the record that Beata did know of those photos. Okay. Your Honor, kind of like you said, they want to talk about some things in DCF, but not other things in the proceedings. We would have liked to talk, and we offered not to talk about DCF at all, if you'll recall. We made a motion on that, and they didn't want that. Okay,
Yep.
so, because they wanted to hear about immunity. They wanted the jury to hear about immunity. Well, that's a litigation decision. But if we were going to talk about more of DCF stuff, we would talk about their involvement with DCF, how they basically prosecuted the case there. People from the hospital were involved doing that. you noted in your long order a question about good faith. The couple cases that you acknowledge you had to follow didn't even talk about good faith. Well, we would have said a lot of things about good faith if we were going to get into the DCF proceedings, but we didn't. It was stayed narrow. I think to come in now and say, oh, well, we didn't get to do everything we wanted is a little late.
Yeah, very much so.
On that day, again, tying into the DCF, Beata sees her daughter in a wheelchair. This is a 10-year-old who, among other things, was forced to defecate on herself, treated horribly. They just downplay this. As we say at the beginning of our response, they just don't get it.
Yep.
They don't get how bad what they did to this little girl was, and for her mother to see it, and then to hear about it when she couldn't see it and couldn't even comfort her daughter. As far as Dr. Smith's negligence or apparent agency, it's a little bit moot or academic in one sense, because there's a question on the verdict form about medical malpractice from the other doctors, and that's answered yes also.
Yep, very much so.
But to stay with Dr. Smith for a minute.
Kaizo Mario, man, I can't play Kaizo Mario.
To say that she didn't have any involvement, I mean, here's a note from risk management file, trial exhibit 2277-068, about the videotaping, and Dr. Smith is all over it, Dr. Sally Smith. She's involved in this. The other thing is that the question of, well, maybe Beata knew she was a DCF or whatever, Child Protective Services person. The malpractice wasn't on Beata, it was on Maya.
Yeah, exactly.
Smith walked into Maya's room as an apparent agent
There you go.
of the hospital. So she's the one that saw this. As far as back to the negligent training, it is relevant for the reasons we set forth and discussed at some length. The hospital is by law responsible for training and responsible for supervision. We also think, for the reasons we set forth, it's not preserved. So if there are any other questions, I'll be glad to answer them, try to answer them. Otherwise, I guess it's break time.
Well, we're going to let Mr. Altenberg.
Oh, yes, sorry, didn't mean to preclude that. Sorry, thank you.
Mr. Altenberg, do you have a brief rebuttal on your new trial motion?
That October 3rd testimony is about video. It's about the stuff that occurred in mid-October. It's not about the photographs taken at the end. There wasn't any proof that Maya knew, that Ms. Kowalski knew anything at all about the photographs taken on January 6th. The record's clear on that. As far as Dr. Smith was involved in some things, she was the CTP person. She was doing investigations. We had to cooperate with her. Yes, she was also interested in seeing what that video would do for her case. That didn't mean that she was treating as doing something that the Kowalskis wanted her to do because they thought she was an agent of the hospital, which is what a parent agency is about. Now, we can be responsible for what we did that day, but it's not because Dr. Smith was interested in doing it.
You finally admit you can be held responsible for something? Whoa, that's a nice
it
admission.
ended up becoming this thing that
We appreciate
inflamed the medical negligence claim, that the CTP person was also interested in seeing the video on that. So that is, if it was anything, that would have gone to false imprisonment, but that is not something that should have ever gone to the jury on a theory of apparent agency for medical negligence committed by Dr. Sally Smith at any point in time after October 11th. So with that,
And before we run on break, let me just ask, and maybe you can think about this over break. Has Maya Kowalski turned 18 yet?
Yes.
Yes, Your Honor, she has.
So do we need to substitute her as the true party? And do I need to change the caption and all that good stuff?
Our tenant's motion to substitute party.
Is there any?
I was going to bring that up in the final judgment. I don't think they need to go to probate court. She's an adult now. It just transforms it. This is going to be a judgment for her, one for Jackie.
If we get there.
And one for the estate PR. If the verdict's good, that's how it would look. It would actually be better to have three separate judgments.
So both sides want me to go ahead and enter an order substituting Maya Kowalski as the party plaintiff for Jack Kowalski as the parent of Maya Kowalski?
Yes.
Okay. I'll do that either today or Monday. Okay, let's take a 15-minute break. I'll be back in 15 minutes.
All right.
All rise for the recess.
All right, so let's discuss a little bit about where we are and why we are where we are. So basically, this is a necessary process for the lawyers because it's all about preserving your issues, which Johns Hopkins has not been necessarily great about. But you have to preserve your issues at every step of the way, right? So, for example, like if you're on defense, like Johns Hopkins is, you're going to ask for a decision in your favor probably a couple times, right? You're going to ask for it right out of the gate in a motion to dismiss. You're going to ask for it for summary judgment, which apparently there were 52 orders for, which continues to blow my mind, right? You're going to ask for it for the jury. You're going to make motions for mistrial. You're going to ask for it at the end of the case, is what they're doing now, right, to preserve the issue. So at every stage of the issue, like from the motion to dismiss, for the many, many motions for summary judgment, to the jury, to now, they're basically doing the same thing. How about we win, right? So that's the thing, right? And so we're asking for a directed verdict, which is something, it's what you would typically do basically as summary judgment. Summary judgment is just a directed verdict. It's a directed verdict by other means, right? A directed verdict is just, I as the judge am able to rule on this because, I don't need a jury. In the case of a motion to dismiss, it's because you have no legal costs, right? You're not suing for a legal thing. So dismiss because there's no law to support you. The summary judgment is after a fact-finding stage. So now the uncontested facts, as now developed, don't help you. So go away, right? The court here, the trial, the court, the jury hears the case, and now we're into the same thing. Look, Your Honor, right? You let this go to the jury. You heard all the evidence. Because actually the summary judgment phase, of course, it should also be noted that it's not the same evidence that's going to be during the trial phase. Because at summary judgment, we're still talking about the evidence that's been made available on the pleadings, right? Been made available in discovery. But that's not the same and will not be the same as what's presented at trial. Like they're not going to present all the same arguments, and they're not going to bring all the evidence for no other reason for time. So like, you could say, for example, that if in a summary judgment, like you're as a judge, there's enough here for a jury to consider, and then plaintiff fucks it up, which we've seen before. And so, I thought that there was enough here, but there's not. And of course, it's not unheard of for the judge to make that decision during the trial and dismiss counsel on the way, which the judge incidentally did in this case at various points, where the judges, I should say plural, the judges did decide things in Johns Hopkins' favor along the way. Some of the counts went away. So they've won this argument in parts along the way. All right. So it could, now that you've heard everything, Your Honor, now that the case is completely closed, now that all the evidence that actually, was presented, which is all that matters, is, in the end, what's presented at trial is all that really matters in the end. So now that you've heard all the evidence, no reasonable juror, blah, 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 so forth, right? And so you're like, yeah, I agree with that. I think that there's, the facts are, wildly disproportionate and the jury effed it up. Which there's definitely a case to be made for that sometimes. Because juries sometimes F it up for any number of reasons. This is why we have courts and courts of appeal to help with the jury effing it up. So, but the standard for the jury effed it up is really, really high, as one would expect, because the jury is the fact finder, right? So you need a lot to say the jury effed it up. It's not just enough to say, well, I have arguments in my favor. Like that time's over now. Right? We interpret the evidence in light most favorable to the status quo. So the status quo at the start of the trial is Johns Hopkins wins because they're the defendant. So the status quo at the beginning is Johns Hopkins wins. Well, we've gone all this way through and we've had all this happen and the jury has now rendered a verdict. So the status quo is now Maya wins. And so now to overcome that, you now have to prove the opposite in light of the fact the jury as the finder of fact made their decisions. So Johns Hopkins is over here like, first of all, juror one, we have more than enough evidence. No, you don't. You don't have anything close to that. And the judge, I hope, very desperately hope, is just giving superficial, well, if I were to do it, how would I do it? Well, Your Honor, you'd have a hearing in which you'd probably subpoena the juror, who then would file a motion to quash because of privilege and tell you to get wrecked. Although he didn't mention that part, but I can, because I can say anything I fucking want. So, if it were me and I were sitting on the jury, I never give legal advice to someone else, but I can say what I would do, right? That's like, if I'm on the jury and I'm married and they're like, what did you talk about with my wife? Motion to quash, baby. Motion to quash. I invoke privilege. The hearing is moot. So, yeah, which is my right. And, that's fine. Of course, I'm not going to open my mouth. I invoke my right to remain silent every single day, forever. And again, this is absolutely in no way dependent in any sense on whether juror one did or did not talk to his wife. I believe juror one that he didn't talk to his wife. And if that's true, he still should invoke privilege for the exact same reason that I, as a lawyer, would beg you with all that is deep in me, with my every last fiber of being. I don't care if you did it. I especially don't care if you didn't do it. You invoke your right to remain silent with the police. Nothing can go right. It will not help. There is no scenario when talking to the police is going to help you. Keep your damn mouth shut. But I didn't do it. I'm going to look guilty. They're going to think I'm guilty. Don't talk to the police. Never talk to the police. So that's what I beg of you to do. So yeah. So good times. Yeah. The judge is going to give a new trial if he invokes privilege. I seriously doubt that. I seriously, utterly doubt that. I completely, utterly doubt that. Yeah, I don't think that's true. I really don't think that's true. Yeah. I told this to a friend and she got offended, and she says from a family of cops. I was like, but you already know this, because cops don't talk to cops. Preach. Yeah, cops don't talk to cops. Preach. Yeah, F up, shut the fuck up Friday. It is in fact a Friday today. It is in fact a Friday today. So today it is shut the fuck up Friday, just like it is every day of the week. Every single day of the week is shut the fuck up Friday. Let us watch this video from the Pop Brothers at Law, actual lawyers who deal with actual marijuana, who have the fashion game down to an absolute T. I mean, these guys are big pimpin' for sure. They definitely got the shtick down. And their legal advice is best legal advice. Let's listen to their legal advice. All right, we'll watch it on YouTube. Screw you.
Mark and Craig, Pop Brothers at Law. We've been warning people, if you are working for an unlicensed dispensary, an illegal dispensary, and it gets raided, you need to shut the fuck up. If you shut the fuck up, you have a good chance that we can make the case go away. Case in point, 3 employees of an illegal shop were busted during a raid. 2 of them said, oh, I'm just volunteering here. The 3rd guy shut the fuck up, and the DA did not prosecute the guy who shut the fuck up. They can't prove what you were doing there. If you're a customer, patient, walked in to go to the bathroom, they don't know. You got to shut the fuck up, and it's Shut the Fuck Up Friday. So review the script. What do you say when the cop first pulls you over?
Why'd you pull me over?
And when he keeps asking questions?
Not discussing my day.
And they ask more questions?
Am I being detained or am I free to go?
And if detained, what do you say?
I invoke the 5th.
And then what do? You
shut the fuck up.
Shut the fuck up Friday. Never answer questions when the cops ask.
Have safe holidays.
Tip of the day.
Do that. Do that. Always do that. They're 100%. Always do that. 100 every time. Do that every time. Yeah. So yeah, so that's where we are. So basically at this point, we're basically having an appeal. That's basically what we're doing at this point. We're doing an appeal before the trial court, if you like. Because that's basically what we're doing. Hey, trial court. You know, things went shit. Can we have a do-over? We're basically doing an appeal at the trial court. That's basically what we're doing right now. And so we're getting a preview of their appeal. It's not going great because a lot of this is findings of fact. And, you know, they're completely right, of course, about the email from Maya's mother saying that. But, you know, it's a question of fact. And so it's up to the jury to determine what they can do or not. And as long as we're not talking about manifest weight, which we're not, right? There's other evidence to the contrary. So, you know, this is a jury call. Go away. But I do almost admire in some ways. No, I really don't. It's just so distasteful. I can't even admire it on a ballsiness territory because it's just so off point. Johns Hopkins getting up, especially with respect to Juror 1, and the kind of language they're using just puts me off. Like, this is the first time in 20 years I've done it. I'm like, now's not the time. This is so obvious, so manifestly clear. This begs the court for relief. This is the most obvious situation in all time. Looking at you know, the clerk of court of Colton County right about now. Seems like a more obvious situation to me, but, you know, okay. You know, SS and these S's. It was so obvious. Well, how did you learn about it? It was pointed out to me. And the judge didn't ask the follow-up question. I was so mad. I really wanted the judge to ask the follow-up question. Who pointed it out to you? How did this come to your attention? We learned it about from Reddit. Say it. Say it. Say it on the record. Yeah. Yeah. So that's basically what's happening at this point. And I can't believe for just a moment. I can't believe for even a moment. Yeah, that's a good thing to bring up in chat for the Gundys. I like that. Where's my chat thing? I'm going to pin it. Where's my link? My link has disappeared. So right, I can figure it out. Yes, I want to go there. Thank you. All right, if you guys, while you're here, do a solid for my friend Runkle the Bailey. He's up for some awards for the Gundys because he's a gun rights lawyer in Canada. He has a really hard job. He's a super hard job. Gun rights lawyer in Canada. I mean, damn. You know? But what happened to my link? Did my bot delete my own link? What bot is deleting my links? I posted in chat and it disappeared. Oh, I posted in my wrong chat. Oh. Oops. Where's the right chat? Too many windows open, man. Too many windows. Windows. All right, there's the link. Please go vote for my friend. I'd appreciate it. Yeah. Yeah, it's all right. I'm a competent uncivil. I only have done this for 5 years. I know what I'm doing. Oh, Lord. All right, so what other questions can I answer while we're waiting for the court? The video's back on, but we'll wait till they actually start. Is there anything else I can answer while I'm here? What other questions about the hearing or stuff do you have while we're here? Is it your chance to ask clarifying questions uncivil? Thank you, Carl Blakemore, for 10 gift memberships. I do appreciate all the gift memberships. They're very, very thoughtful. Thank you. How turning 18 affects subsequent proceeding? It doesn't. They're just replacing her name in the caption because it was, her father on behalf of Maya. And now that Maya is, an adult, it's just Maya. So they're just changing the caption of the case. It happens. It happens for a number of reasons. Yeah, captions of cases change sometimes. It happens a lot, for example, if you're suing a person in their official capacity, in particular, as the official changes, you substitute the names. Yes, they went over the slanted S accusation, and yes, I'm disappointed in Judge Carroll. Judge, I would be a much more obvious judge with my displeasure, which I think is appropriate. In my humble opinion, I have the right to judge you, because I'm a judge and all. And if you're stupid, why? Why appellate counsel, not trial counsel? This is trial counsel now. This is trial counsel for this proceedings. But, they have appellate counsel all ready to go. Both sides had appellate counsel ready to go because, they know there's going to be an appeal. Everyone knows there's going to be an appeal. So both sides have appellate lawyers ready to go and in the courtroom, which is pretty unusual, incidentally, but it's kind of interesting. So yeah, what can you send me for Christmas? That's a good question. What can you send me for Christmas? You know what? I know it's a bit lame, but honestly, just cash. I mean, cash is great. So if you want to make a donation to me via my PayPal or something like that, that'd be great. If you just want, because PayPal doesn't take a huge cut, and then I can use it for some future purpose. That'd be great. PayPal only takes 3% as opposed to YouTube's 30%. PayPal is better.
Is Remediator. Mr. Altenberg?
I also accept jerky. That's true. I do accept jerky.
And Your Honor, by Remediator, I at least am using a more generic concept of the damages problems in this case, because Remediator is
A
the last
turkey-sized
in the area
IKEA
where I
meatball
at
would
least don't
also be wonderful.
hope you actually
If you
have
happen to
go,
be in the
because that's-
UK and can
I
somehow
don't
ship
actually
me
think
a
that
turkey-sized
these numbers
IKEA
allow you
meatball,
to do a
that would
Remediator.
be
If you
fantastic.
thought you could, but these numbers are so far off the mark that I don't think they line up with what a judge can do with Remediator. But what I'd like to discuss is the methodology of the per hour, per element, or component of damages and the errors and relating to that, first as to Maya's claim and as to the wrongful death claim, and then finally the damages as to punitive damages. Now, you know that
Do
we
I think
filed
Judge
in
A would have dealt with
advance
this better? Probably.
motions to try to prevent him from doing his per hour,
But I
per
think I would
component
go a
approach
step
to this.
beyond.
And you denied anything other than my ability to see the
I think it
numbers.
would be much more
When I saw the
manifest.
numbers, I explained to you before
That'd be an
closing
entertaining
argument
judge to
that they
watch,
were
probably. That's
much higher
a
than
good
the
thing.
range in which a jury was free to operate.
Watch
And
Judge
that
on
he was
Civil
going to
lose
use
his
this
shit today.
PowerPoint that was going to have numbers that between the two claims totaled $200 million, and he was going to use them as totals to this jury, and that you should stop that.
Only
And that
30
it was
are being
wrong, both
given out.
because it was an artifice, but
Lame.
because it was false statements of law, because damages are supposed to be done claim by claim by claim. And you basically said you were going to go allow him to do his argument, but that he did it at his own risk. And he did exactly what I told you he was going to do. He used these numbers to put forth things that are not only beyond the range in which a jury is free to operate, they, especially as to Maya's claim, were misrepresentations of what they were supposed to do. And in that context, there were things that in fact he did not prove at all. So I continue to believe that the use of these was something that should have been prohibited, and that they warrant not only a new trial on damages, I think they inflame things enough that wouldn't warrant a new trial on everything, but categorically they would be this is something that he did that demonstrates a need for a new trial on any claim that damages were awarded on. Now, as to Maya's claim, the impact on this is interesting. Now, let me sort of start with the economic, because the economic is basically
We're
past
arguing
medicals
for
is the big
money
issue.
damages go down, please.
I point
That's
out
what
in
we're
the
doing now,
motion
by the way, just in case it was
They
unclear.
never
Money
actually
damages go down.
proved any past medicals. The PowerPoint and all of this didn't ask for past medicals to Jack Kowalski, and yet the jury gave him, between false imprisonment and battery, a combined total of $1,513,498 in past medicals, when even the 3 years of bills from the family for everything that family had to Aetna was substantially less than that. And those bills really aren't related to anything. You've had a lot of personal injury cases. You know that if there is a medical treatment for a battery or for a false imprisonment, you need a doctor to say, I treated for this, my treatment was reasonable and it was necessary and my bills are reasonable. You got to have some version of that. And yet there was no evidence of that at all for any of the false imprisonment or for the battery. And there was no claim, by the way, at all in medical malpractice for past medicals. They didn't put in evidence or make a claim that the medicals in the hospital were something that were be recoverable under medical malpractice. So there was no claim there at all. So not only they did not ask for it in the PowerPoint, there was no claim in the medicals, and there was no proof for those in the record. But what he did was he put his large numbers up and basically just tells the jury, this is how much I want in total, and just kind of go in and fill the blanks in some fashion. So he's complaining, by the way, that, well, I didn't make recommendations as to specific numbers. He didn't do specific numbers at all for the Maya Kowalski claim. He just put this stuff up and said, I want it all, just give it to me somehow. The problem is that he never proved his economic past damages. The amount he proved was zero for that. And that is what that amount should be on the verdict form if the jury was following the law. Now, as to the economic damages, then we have, the non-economic damages for Maya. He uses this approach of having her have human damages for this component and that component by hours per day. For every day of her life, for the rest of her life, she will have these damages. And he puts together these numbers that are $107 million for all of the torts involved, the intentional infliction, the false imprisonment, the battery, and the like. It's going to be almost $8 million, which is a number, you heard the evidence. There's certainly some value to those claims, but it's nothing remotely close to what any jury in Sarasota County or any county in Florida has ever returned for the things that you heard as the evidence of this. I told you they would be a magnitude higher. I think they're actually more than a magnitude higher than what happened here. And yet the jury came back with the numbers that I've described in the motion that are sky high for all of those things for Maya. And they are clearly excessive, and it was brought on by the argument. Now, as for the wrongful death, it's a tiny bit different, because in there, at least, they are broken down in the PowerPoint. And on that one, by dividing the pain and suffering concept into components, and once again, using hours a day. By the way, Maya in particular is having pain and suffering for 15 hours a day for one claim and 12 hours a day for the other claim. I guess they're happening simultaneously as pain and suffering is tacked on one another under this theory. But he ends up with Jack Kowalski having a claim for $26 million, which is more than practically, I don't know of any medical malpractice, any wrongful death claim in Florida approved by an appellate court where a husband got $26 million. The highest numbers I've seen are $15 to $20 million. And yet he's getting this And the jury, this basically doubles it, gives him $50 million. Because I guess because they got $200 million to spend and they're trying to figure out where to plug it in is what they did.
What if I agreed with you that the wrongful death component for Mr. Jack Kowalski was too much? How does that work? What if I granted a remittitor as to that claim? And then let's say the plaintiffs disagree. Are we retrying the entire case, or are we just retrying that one claim?
The law on this is that I can argue that I was entitled to a new trial on this. And once that is denied, then you go on to remittitor. So I don't necessarily have to accept a remittitor myself, and I can challenge the denial of the new trial. So I have made all of these arguments, but the notion.
So you're not going to
Can
accept the
I agree
remitter
that
you
we
asked for?
start off with new trial, juror misconduct, and then we work backwards. And if we end at the beginning, then we're doing a new trial. If we get farther down the road, then it depends on where we are. I get that.
So,
But assume for the sake of argument, and just for the sake of argument, this is obviously not a ruling. If we're in this space where I'm talking about remittitor and having denied everything upstream.
correct.
So how does that work if I grant the remittitor relative to wrongful death as to the survivor, Jack Kowalski?
Well, the theory generally is that you think the jury was in, it's easier to do, by the way, with economic than non-economic, number one. But with this, the jury was in the range, and I'm going to adjust it by downwards by 20%, or sometimes upwards by 20 or 30%. Judges will do it because you can do it either direction. And you could do it here, but it's $50 million. You'd have to drop off $40 million off this thing to get into a reasonable range for this, or at least down to 15 million of the maximum amount. Well, theoretically you can do this. The law also says you're not supposed to become the sole juror or the seventh juror making these decisions, and because these numbers are so far off the mark, well, I'm telling you, if that's what if you deny everything else, I want you to do this. I got to tell you that I don't actually think this case fits the scenario of a remittitor because of that.
So you're asking for remitter,
Well,
and also
I need you to
simultaneously saying you
assume
don't think it can be
that
done.
I've denied everything upstream, and we are talking remittitor.
Johns Hopkins wants it both ways.
And
once
I've
again,
given numbers,
Your Honor, I want
that.
reduction.
and I've
Also, I
given
don't think it
numbers
can be
in
done.
in my motion as to numbers that I think you should use for that, and I don't have them memorized, so I'm not going to give them to you.
It was
but-
pretty low.
But you would have to come up with what you think was essentially the maximum legal range in which the jury was free to operate in awarding these amounts.
And then mechanically,
But
how
to do that, you'd
how does
also
that
have-
work?
Oh, no.
You sit down and use the,
Are you asking me? I don't know.
There's no scientific method for you to do this. You just make up a number, Judge. That's the problem with remitters, is that they reach a point where it's not a judicially normally based decision process. But if you do it, you're just going to have to say, well, maybe I've watched Sarasota County cases and wrongful death. I've got a sense that husbands normally get $7 to $8 million in a case like this, and that I'm going to stick with that range because that's the appropriate range for this case. That's how you would do that in this kind of case.
And then assume I did that, and I'm not saying the number, but
Yeah.
assume I did that, then the plaintiffs would have the option of accepting or rejecting.
Yes.
If they reject,
Then it
are we
goes-
retrying just that damage claim, or are we retrying the entire case?
If you were convinced that this didn't show damage, that it didn't impact everything, and you rejected all the other motions that I've made, we would only be retrying damages at that point in time.
As to that claim and not the
That
other claims?
claim and not to other claims. And you're right, it gets really complicated here because there are different claims that would have different outcomes on that. But it's not inconceivable that among all of these, there would be something where you could decide that a remitter was appropriate, they could reject it, and you would have to have a new trial.
This is
only on
typical,
damages. I'm
on
just
Twitch,
not
Retired
conceding
Guy. This
that
is typical.
Generally how that would approach in this particular case. Now, if I can shift to the punitive damages,
Sure.
the damages on the punitive claim,
Thank you for participating on Twitch.
$50 million. And you know what the evidence is as to these things. On the first week, we kept her. The girl was sent to us because the doctor thought she needed to be in our emergency room. We concluded he was right, and we kept her there for a week. And we kept her in the pediatric intensive care unit. Now, there may have been medical negligence and other things, but as to false imprisonment, that's what we did. And we did it, as I've explained, because I think we felt that it was the morally correct thing to do, and at least for 24 hours, it was the correct thing to do legally as well. But when you look at the elements in the final verdict form, it's, well, did we do this because we were solely motivated by an unreasonable financial gain desire? There's no evidence of that. There's no reason to think that this one or any one of these things was done for financial gain. Was it unreasonably dangerous nature of the conduct together with the high likelihood of injury resulting from the conduct, and was actually known by the managing agent or other person responsible for making decisions on behalf of the hospital? Well, was it truly unreasonably dangerous? Was there a high likelihood of injury to Maya because we kept her in a pediatric intensive care unit? What was there such when we moved her down the hall and surreptitiously videotaped her, which is not actually an element of false imprisonment? We just moved her into another room. Now, we have to accept the evidence. She says that she defecated on herself. I don't believe that she said that some nurse sat there and watched her and said, I'm going to wait till you defecate her on herself. She claims she defecated. Now, you can go through, if you want to, because they say they're not in evidence, but every single one of those clips is in evidence. We only, between the two of us, I think we played maybe 5 or 7 of those clips to the jury to demonstrate that it's, a room in which she is a room like any other hospital room, and she's got a commode next to her bed like she did at her other one, and that she's getting PT and there's a nurse in the room and the like. So whatever that is, you have to accept the facts as they are. But that is something that warrants us to have punishment of, I lose track of which one's 10 and $15 million, but these are multiple millions of dollars because we kept her in a pediatric intensive care unit, because we moved her down the hall into a room and had supposedly treated her different by what she describes. And then finally for the photographs that we took. Now, the photographs we took, because once we started back up at that point in time with Beata having Facebook time, the next day she has cuts on her body, and Dr. Elliott reported that he thought she was self-inflicting. And that the record shows, risk management knows that we're worried that she's now self-inflicting and mom's talking to her. And they wanted those pictures taken before and after she went.
But isn't the evidence also that the lesions are symptomatic of CRPS? And so don't I need to assume that those lesions are
what you have to assume for this case, for this part of it, and maybe he was negligent in that. If he comes back in here today, he's going to tell you those aren't CRPS lesions. That's what he believed, and that's what he told the jury he believed. And so maybe that's a negligent misdiagnosis, but was that something that was done at the level of intentional misconduct for punitive damages? So on all of these things, when you compare what we did to the tests,
your husband's 30
these
years
numbers
junior.
are multiple times higher than they should be.
Should I also consider the evidence that was presented that the hospital did not believe Maya? I mean, how am I supposed to factor that, Mr. Altenberg?
I'm looking at a cut on a forehead that looks to me like a scratch, to be honest with you. I'm not a doctor. But,
Re-arguing the facts.
It's not necessarily that they disbelieve this little girl. I mean, she's there, they think in part for psychological reasons. It's not necessarily that she's doing things intentional in this situation. But I mean, you can factor that in, but if you do factor that in, that makes it $15 million or $10 million or $50 million for these things. That's an enormous amount of money for factors, for things that, for which there's, no evidence that she got medical treatment before. We've suggested that she probably ought to have some psychological therapy that she's never had.
Why didn't you provide it to her?
In this case, but whatever that is.
You know why she didn't
these
get
are not
medical? Why she didn't get psychological counseling? Because you would
tobacco
have subpoenaed
companies
her
get hit
medical
with $10 or
records
$15 million, but
and
they
dragged her
knowingly,
therapy into this court
intentionally
case.
hid from the fact that they were selling
Thanks.
a product that was going to cause you an addiction that could lead to lung cancer. That's the evidence in those cases. They get high numbers because the facts are really pretty outstanding in those cases, and there's multiple people involved in that. So if you look at this the way it is, I submit to you that those numbers are far out of range for anything that's reasonable. Now, can we not file bankruptcy? Well, probably not. But the front end test is, does this conduct warrant how much money as a deterrent? And these numbers are sky high on that. And
I'm just, because we're in a remitted or situation.
And you can do a remitted on this as well. Yes, you can. And
It's just your argument seems to be more of a new trial type argument as opposed to a remitter argument on this punitive damage, because I don't hear you saying that.
well, the biggest reason I think there's a new trial, and it's this last part, is when we get to the claim about whether there was specific intent to harm her. They are correct, by the way, and I was mistaken at the time of trial, but I can be perhaps forgiven for the fact that I found out they wanted this in the morning, had to leave the courthouse, go back to my hotel room and try to research this and come back that day. But the standard jury instructions on this, if I can find this in the form, this is bracketed language, so it's optional bracketed language. And it says in comment 6, instruction 503.1C2C should be used only after the court has determined the evidence includes some additional circumstances that may affect the amount of the punitive damages. Well, the way for you to, because this, if you read the text of the statute, is not a measurement of damage. It's
Just so I'm clear, are we talking about the adding the question in phase 2?
Yes.
That
Yes.
actually was the proper way of doing it?
Well, I will tell you that the standard jury instruction puts that option in there. I'll tell you that the standard jury instruction is dead wrong, because it's not something that is used just to measure damages. It's something that lifts the cap. The jury never knows about the cap. This is something that takes you from having an award of up to, I'm not going to have the number in front of me, but it dramatically increases the ability to do it. But it also puts into the mind of the jury, well, was there a specific intent to do this, which changes the dollar amounts in this thing.
Well, but let's.
You can't change that cap unless you have clear and convincing evidence of something.
I mean, isn't this really an academic discussion?
No, it's not, because.
Why not?
Because they were supposed to give me their jury instructions by mid-August. They didn't. They never gave me that punitive damages instruction until the morning it was going to be used in the afternoon. And that was my first notice that anybody had any thought that this case involved specific intent crimes by my doctors. And I submit to you that there is no evidence
Sounds like
that
a
anyone
question of
in the
fact,
emergency
sir.
room or the pediatric intensive care unit had a specific intent to harm Maya Kowalski when they kept her there under their care. There was no specific intent to harm her in the other two areas as well.
But isn't the cap not exceeded in this particular case anyway? So isn't this really?
It's exceeded because all the other damages are excessive. And because you put this thing twice on the verdict form for them to focus on, well, yeah, we should give them higher punitive damages because there's a specific intent. I submit to you that there's no evidence of that. And I never got to make any predicate motions to have that stricken from a complaint or stricken from jury instructions. I never had an opportunity while there were witnesses there from management, because this is a management test of specific intent, not that
You never had the
to
chance?
be able to put on evidence about this.
What are you
Well, but-
talking about?
Assume I messed up. That would have been a mess up in the punitive damages portion.
Yep.
And Mr. Shapiro's argument seemed to be very persuasive to the jury. The fact that the jury awarded 10, 15, and 25 million only when there was evidence of what, $500 million of securities and free cash. So I'm just saying Mr. Shapiro's argument seemed very persuasive about every dollar you award Maya Kowalski or the family is a dollar that you can't give charitable care in Sarasota County, was the argument.
Okay, but when General Motors does a punitive damages thing that under the measurements of how you determine the amount is worth $3 million, the fact that General Motors has a gazillion dollars doesn't mean it's okay to transform it into $300 million.
What are
The
you
money
talking
amount
about?
is there just to demonstrate that you cannot bankrupt them.
Punitive damages are by
But
their nature
the
designed
fact
to
that
punish.
someone is rich or poor doesn't necessarily
Your
change the
available
amount
assets are
that's
relevant.
needed to deter other people in the future or to deter these people. I mean, this is
I'm not
deterred
sure
the
why
hospital.
General
They're going
Motors
to be
got
very
dragged
careful
into this,
about
but
who
that's
they
where we are.
bring in and how long they let them stay in if they're in DCF custody. That's what's going to happen. We could have discharged this girl about the same day as the shelter order. If we'd let her go on AMA as they wanted, DCF would have filed it here in Sarasota County. The judge would have entered the same order. There'd have been a pickup, and she'd have been in Sarasota Memorial Hospital.
You know,
and they
Your
would have
Honor,
been
when
in the
I went to
hospital not getting
Chipotle
AMI. That's all
last
that
time
would
I
have
was there,
changed.
Let's
they had like 15 available
be clear,
toppings,
because
but that doesn't mean you should put them
when you
all
say
in
nothing
there,
else would
because
have
if you did, it would make,
changed, are you
the bowl
suggesting that
really
some other
unpalatable,
hospital would
be
have
overflowed with
battered
toppings, so
Maya
you shouldn't put all
Kowalski?
$15
Are you
just
suggesting
because
another
you have a
hospital
robber.
would have falsely imprisoned her? Those are issues that had
No,
nothing,
Your
that did
Honor,
not
when last
flow
time I went to Burger
from
King,
the
they told me I
DCF
could have it my
proceeding.
way, but that doesn't
So,
necessarily mean
I
that I
mean,
should
that's
have
what
to
your
do
argument
all I
seems to
want,
be.
because that'd be unfair. The fast
No,
food
my
workers
argument is
who,
on
so
that,
I should make
for
my request much
deterrent
more
purposes, you've got our attention. It's just unfortunately it's going to have adverse effects on this. Because we don't think we falsely imprisoned her by moving her down the hall or keeping her safe in a PQ. Admittedly, those photographs are not pretty, and maybe we should not have done that, but I do not believe that rose to the level of punitive conduct as compared to compensatory conduct.
Thank you, Mr. Altenberg. Who's going from the?
You know, Your Honor,
Claims center.
last time I saw a Taco Bell ad,
Based on the
they
court's
told me to think outside the
question
box.
at the start
And I don't know why
about
you're so
the damages
constrained by the
to,
box of the
Jack
law, Your
Kowalski
Honor. I think you
based
should
on
think
the
outside of it
wrongful
for the
death.
betterment of the
I
children.
have an answer for the
Johns
court.
Hopkins.
If the court noted the jurors were all, from my view, and no offense to any of the female jurors, they're between the ages of late 40s, maybe mid to late 40s and into their 70s. I submit to the court that these folks know what it's like to grow older and the challenges that are ahead of them. Now, the court's familiar with the law, but there's a quote out of Hawk versus Seaboard Coastline I think is appropriate. Damage for mental pain and suffering is one of the late developments in the law, and its potentialities are not restricted as they formerly were, because so much has been learned of the evil consequences that flow from mental injury. And that's back in 1989. The reason I think that's of interest to the court is, please remember Dr. Brewerton's testimony, which I think was reiterated by another psychologist. He's a psychiatrist, that PTSD actually forms a lesion, a permanent physical injury to the brain, which was never going to change and never going to heal. Now,
I haven't heard
I'd
that
like
one
you to
before,
keep
but
that in
okay.
mind with the idea that from the jury's perspective, now Jack Kowalski was faced with should have been the greatest part of his life, trying to get his kids along, but with a wife that loved to do the same things he did. They got along well until this. They had built a great life together. They were happy. They had it all. And then that's when all this stuff came in. So the jury then is looking at somebody who not only loses the ability to live out some of the best years of their lives, and he's not an old man by any means. He's in, I think, his late mid-50s. But my point here is, Judge, they understood the waking up in the middle of the night, wondering, who's going to take care of me as I get older and the kids are out on their own.
PTSD,
taking care of a daughter that
apparently
has
PTSD does cause physical damage to the brain. I was unaware of that. I've learned something
to
new.
deal with, which is
Uncivil
so
gains
uncertain.
knowledge.
And having two kids with deep-seated now psychiatric, psychological problems. So his loss of Beata was based on a 2023 jury looking at what we pay now in this country, in this state, for different things. We'll drop $100 million to get a kid out of a hole.
I mean, I sat through the whole trial as well, but let's talk about the mechanics of Remediator as it relates to Jack Kowalski's wrongful death claim as a survivor. And
Yes,
if
sir.
the court were to grant a Remediator, how does that work as to that claim?
I hadn't researched it as closely as my appellate counsel could probably speak better to it, but I would understand.
I mean, I'm here, and that's the question that I've got.
Honestly, it would be better to have Mr. Elliott.
Mr. Elliott,
answer that.
why don't you tag in? I know I'm violating the two.
Appellate counsel's now going to argue at trial? Okay. I guess that's what we're doing here.
Of course, we don't think there should be a remitter.
I know,
But-
I know.
I know.
But I'm having to deal with all sorts of.
Yes.
I mean, if we find that there was, a new trial necessary, we don't even get here.
Yeah.
It's.
I understand. I think what you heard before is essentially correct. You would remit to the highest number that you thought the evidence supported. The law is clear on that. We've said that in the memo. Then the plaintiff gets to elect, do they take the remitter, and then that goes, you enter a judgment with everything in it, or do they reject the remitter and get a new trial? Assuming the plaintiff accepts the remitter, you would enter a judgment. The defendant can still appeal that because they wanted a larger remitter or they've got other issues.
Okay, so.
And the retrial, if the plaintiff did accept the retrial, it would be limited to the damages issue on whatever you remitted. You would not go back and try liability. You would not try any other issues.
Okay, well, that answers my specific question.
Great.
You would be able to get a judgment entered
Yeah.
on the remainder. I think that's important.
Yeah, if the remitter is rejected, or excuse me, if the remitter is accepted, as I said before, there would be, whatever it would be, the judgment, we've submitted a form, and whether it's 1 or 3, it would be, you would enter it with that number in it. So there'd be a judgment entered. And that's, I know we're coming to that issue, but that's an issue because it's a large issue on interest. It's not accruing now, but will be once the judgment's entered. Is there, I don't know if you, I was going to respond to the punitive damage part. You have more
If
context
the
for
court's
it?
got questions, either one. Take your pick, Ed.
Mr. Elliott,
Okay.
he's standing there.
Your Honor, on the punitive damage issue, we have threshold issue is the same issue for compensatory and punitive, which is with a couple of exceptions, they didn't suggest any numbers to the jury, none. They suggested like
problem.
one number on, actually, if I could have that sheet.
It's a big old problem for Johns Hopkins.
That's the one. Thank you. Sorry. 272,000 they suggest under medical malpractice. They didn't suggest any damages for any other categories. And then they suggested 500 to 1.5 for each plaintiff under the wrongful death count. No others. And, there's case law we've cited that says, well, if you don't give the jury anything to operate from, kind of hard to come in and say these are too much. I mean, they could have come in and said, it's well recognized that you can have the per day, per hours, just a variation of that, and there's cited a case where they've done it. But if they thought that was crazy, they should have come in and said, those numbers are crazy. Do this number.
Yeah, that would be good. That'd been real good.
So as far as the punitive damage numbers specifically go, they keep wanting to focus on the physical, we weren't that bad to her physically. They just want to eliminate the mental part of this, the mental effort to break Maya and break her family, and in particular her mother. That's what this was about in large part, and I think the jury got that. The results show they got that, and these all coalesce together. All these things, as far as for the things for Maya, they did different things, but they all came together to cause the situation she has, the damages she has, and that's, to apportion those out. They could have suggested some other way to apportion. There's nothing wrong with apportioning it. Those are, if you have a typical situation, you have a one car, bam, accident, it's done, that's it right there. That's not what we have here. We have different things over a period of time. And we analogize it to the situation where you have, two injuries and one's caused by somebody else, and the instruction is, well, if you can't apportion it, then you give it all against the defendant. I mean, here, we didn't have to get to that because it was just one defendant. As far as them saying we didn't know this was coming, their memo at pages 41 to 45 complains that for a long while about Dr. Newberger's testimony. And he was talking about the intent and how bad their actions were, and that they were intending to harm the family. So they knew it was coming. That was there. And as we pointed out in our memo, and we argued this with regard to other things, you don't plead every nuance of the case and every little thing you're going to try to get to when you set out to plead the complaint. So we think that was covered. Do you have any other questions on?
No, sir.
Oh,
No, sir.
okay. Oh, well, I may have one more thing. Let's see. Oh, yeah. Well, I think you made this point, which is you've got $50 million. I mean, part of the test on the punitive damages is how it compares to the worth, and will it deter it? And you have to have a larger number to deter somebody, with $1 billion in assets. So that is appropriate there. It is not. Thank you.
Mr. Altenberg, any brief rebuttal?
A couple of things, and I'll just be very brief. As far as specific numbers, I know you're supposed to make those suggestions. I wrote the opinion, and we did make the suggestions. The reason I filed the transcript yesterday to show my objections up front and what Mr. Shapiro did is that we did suggest numbers for one of the false imprisonments that we thought was important to do. We suggested a number for medical malpractice, and we suggested up to, I believe, $4 million for the wrongful death case.
But you didn't tell that to the jury.
We did put those numbers in there. The people who didn't put numbers in for Maya are the plaintiffs.
Bullshit.
They come and say, well, we can use this whole ball of spaghetti again and just tell them to throw it out however they want. Well, I'm sorry, but twice the jury instructions told them those cases are to be tried separately as if they had been tried all by themselves. And then on every single set of instructions, the standard instructions tell them to award damages for this claim, and for the amount for this claim should be reasonable for this claim. And so for them to walk in here without any case law authority at all and say, oh, we can just say, oh, the total damages for these 5 torts are $1,007,000, and therefore you should just kind of fill in those lines any way you want to. That's not appropriate argument. But it was an artifice, it was a false statement of law, and that's what impacted this verdict. So we need to have a new trial because of that. On the specific intent, even if I'm wrong that they didn't need to plead specific intent, keep in mind all they pled was willful, wanton, malicious. We tried all of these punitive damages on the complaint that said willful, wanton, malicious. That's not too close to the target. But our understanding was, we actually got an extension on the jury instructions that we would work these out by the middle of August. And I gave all of the liability instructions and asked for damages instructions. And the day I got an instruction that says specific intent injuries to lift a cap on punitive damages was the last day of jury deliberations. That is not fair notice to me. And I would have done
But they
things
didn't go past
dramatically
the cap,
different
so it doesn't
had I
matter.
known that.
It didn't
Frankly,
go past
I
the cap,
wasn't
so
in
it doesn't
the courtroom
matter.
when
It's
Dr.
irrelevant.
Newberger testified, and I didn't read that stuff till after trial. So I don't think any of that counts. Thank you very much.
Now, the next topic we're going to go to, and I'm going to preface this by it assumes that we get to the point of entering a judgment. No one should assume that a judgment is going to be entered, because I still have to deal with juror misconduct allegations, the motions for new trial, all the way down. So I understand that this is more of a discussion as to mechanics, but let's talk a moment. Assume a judgment were to be entered. Is it a single judgment? Is it 3 judgments? Is it, what do we do about that whole discussion that Mr. Altenburn had with, I think it was Mr. Anderson, about the lien? So who wants to kind of talk first about those issues?
I'm happy to say that, I don't know whether it needs to be 1 piece of paper, 3 pieces of paper, but it is legally a judgment for Maya, legally a judgment for Jack, and legally a judgment for the personal representative of the state. And from my side, if you enter these judgments, I don't have to appeal them all. I could appeal one and not another. And if we were doing remitters, they could appeal one but not all. So just from a practical standpoint, of what I attach to notice of appeal, I would prefer to have them be 3 documents rather than 1 document. I'm not telling you that you can't put a staple on this.
Your Honor, we think either way works, and we're fine with 3. You have some other questions? I'm happy to go to those.
Well, the next one, let's talk about the lien issue. Because I know there was disagreement in open court. If I have the transcript, I haven't gone back to look for it. What is that? How does that work? And then also, because sometimes I'm asked to put the insurance carrier on the verdict form as well. So talk to me about those issues.
Let me distinguish between set-offs and liens, and putting a judgment carrier on the judgment. I'll represent them. I don't think they actually want to talk about that. The lien is the hospital, whoever has a legal right under their contracts to get reimbursed from the judgment, they have to negotiate with and work out an amount. And normally the defendant's pretty well outside the picture, which is why I've never quite understood what that
Can't hear anything. It'd be nice if I could, but here we are.
now in the insurance company. I am entitled, if you actually found that there were proof of medical bills for those, for the false imprisonment and the battery, if there was an award of past damages actually proven and that was there, I do have a right to come in on the set-off and show that the insurance company paid, a smaller amount than the amount that was blackboarded and get a reduction on that. The confusion here is nothing is blackboarded, so I don't quite know how that plays out here. But finally, if you leave me liable, my client liable,
At least it doesn't have the iron lung doors. That's a very fair point. I appreciate that.
I guess $2.5 million, and I will be making some form of a set-off claim for that amount. I don't know the terms of the settlement, so I can't represent exactly how it impacts that. But if we're liable for her, then the fact that there's already a settlement for her is a factor that we'll have to resolve by a settlement motion. The medical bills I'm talking about, that set-off and the Smith are the only 2 that I'm aware of on that. There's no other kinds of insurance that you get.
Judge, I think this is a split again. I apologize. I think as to the lien amounts, that is a separate hearing. I think the court's question is, do I need to put any of the lien holders on the judgment, if that's what the court was asking? The answer to that is no, they're protected by statute. So we would have then a post-trial determination on how much they get paid back, but I don't think that really affects the judgment, right? That's something that we're obligated to do out of any recovery. And the second question then would be, as the liability carrier, in this case MCIC Vermont, and whether they go on the verdict form. Is that The court asked-
I don't know who the carrier is or if there's a carrier or not. I don't know.
Yes, sir. There is, and the law is that under the non-joinder statute, that once a verdict is reached, then they may be added to the judgment. However, there's a question about whether they asserted any type of defense to coverage, which my understanding is the only thing they asserted was as punitive damages, which they have a right to. So if we can join them on the verdict form, except as punitive damages, on the judgment, except as to the punitive damages, I think that would be appropriate.
I can speak just to the statute. The statute says that once the judgment is entered, the plaintiff has a window of time, I think maybe 45 days, to take certain steps that would allow them to join a carrier who has no coverage dispute as to something. But I don't represent that insurance company, and I've never seen their insurance.
So the issue there would be, I would enter the judgment, assuming we got there. And again, it's an assumption. If we got there, I would enter the judgment, and then the plaintiff would have to take whatever they needed to do. But the issue with the set-off, though, isn't that something I would have to do prior to entry of the judgment?
Well, typically, from what I see, the judgment is entered, there's a motion for set-off as to the amount of the judgment, and that's a hearing, and then there's an amended judgment that pulls it down. You see that most commonly with PIP insurance and things like that. I don't know how to do a set-off until I see the number of the judgment.
You all know that whether you pled set-off and specific as to which party and amount?
I know I pled that I had a right to set off the amount for the settlement.
I know earlier you did. Judge, I think there's some issues that need to be handled there, but that would be a process of post entering a judgment if it was necessary then to reduce it. The entry of an amended judgment, I think we could probably find a way to do that without burdening the court with any more hearings. I mean, that's a pretty mechanical process. We know how much it is, so.
You get into a bit of an appellate timing issue because we would probably have to appeal a judgment and then have a relinquishment just to be safe because of the amounts of this to resolve the setup. But there may be a way to do it from a preliminary order of the court. I'm not sure about that. The other thing I would point out, Your Honor.
So, because you can't really hear, they're just talking about the details of exactly how the order should be entered with respect to like insurance carriers and other stuff. So they're just discussing like the finer details of the exact nature of the order.
That might require, the parties can't resolve that, if maybe we can, that might require some additional resolution. That won't stay the appeal times, but will probably still be an issue.
That's upon filing a notice of appeal, then to preclude execution, then you would post a superseding bond. I agree it's capped. What I don't know is it's capped per party or if it's a total cap, but that's something that I don't think we have to worry about bringing before the court. Either is or isn't by the statute. So in our view, Judge, you would simply enter a judgment based upon the amount that the court determines, again, not prejudging where the court's going to go on this. And then if there were a need post-trial for an amendment, then we can take care of that. But to us, it's extremely important that we get a judgment filed, obviously, because interest and other needs.
Am I correct in saying that interest does not begin to accrue until the court enters a judgment? Or is there a period of time post-verdict that interest would accrue?
Well, that was an issue as to pecuniary and non-pecuniary, as to whether there's prejudgment interest on the liquidated amounts, which would be the past wages and medical bills. Did we determine that?
I don't think we're asking for interest, John.
All right. So then it would be simply from the date the court enters it. Obviously, we would prefer to get it entered sooner than later, because we are talking about significant amounts of money.
And Your Honor, one thing I would add on the insurance adding issue is I guess I need to look back at the statute. I thought the insurer had to be added by the time of the judgment. I didn't think you could go back and do it
That was my understanding.
within a window afterwards, so we need to look at that, because that would also impact whether that was going to be done. So we'll look at that right away and let you know.
I don't have the statute with me, but I'm confident that it's done after the judgment, right? Because you actually have to serve them.
So we just need to look at the statute, Judge.
Well, here's my thought process. I will let you all know sometime next week whether we're going to have a juror interview.
Don't do it. Next
I'm
week?
not going to rule on any of these other motions before
I guess it is Friday, so
resolve
technically Monday is
one way or
next
the
week,
other
so.
the issue of juror interview. And if I grant a juror interview, I will not rule on any of the downstream motions.
Invoke spousal
after
privilege,
I
motion to
resolve
quash.
that juror
Motion to quash.
misconduct
Spousal
allegation.
privilege.
So
Remember these words.
I'm not going to enter anything until after that issue, because to me, it's more of a threshold type of issue.
Motion to quash. Spousal privilege.
I'm not complaining, but they wanted expedited excerpts, a bunch of them. And so the court reporter has been doing all these excerpts. I think now is about the point where she can begin to fill in everything and start doing a transcript from day one.
Oh, I like the word too. Quash. It's a cool word.
Sort of
I like quash.
that by early January.
Now, is there anything else about the topic of entering a judgment that we should or need to address? Because, ultimately, if I am going to enter a judgment, whenever I resolve all of these motions, I'm going to want to do it as soon as possible. Obviously, if I grant various motions, it might.
Thank you
there
for the
might
almost
not be any
2,000
judgment,
people
it might
watching,
be a
by
partial
the way.
I just don't know how it's going to shake out.
By the
I-
way,
I
earlier
just don't
someone
know yet.
mentioned that
So,
there were filings today in this case
But is there anything else
that I haven't
we need
seen.
to address?
So
And perhaps
I don't know if anyone's
you all
emailed
need
those
to
to me or whatever, but I'd love
talk
to have
amongst
them so we can
yourselves
discuss
about
those as
that
well.
set-off issue? Maybe there's an agreement. I know what I've seen in the paper, but I don't know if that's the true number or not, so.
From our point of view, Judge, the only thing we can ask is the court set a timetable that say, by midweek, as the court stated, I'm not trying to put any deadline on your ruling on the juror issue, but by midweek, we submit whatever answer we come up with on that point. I don't want that part to drag out.
Wait a second, the answer on, are you talking about the insurance issue and whether to add? Yeah, my hope is that you all can knock that out here in the next few days and just let me know whatever it is. Now, I'm assuming that there is a question of confidentiality relative to the settlement with Dr. Smith and her entity. So you're gonna have to figure out how we're going to communicate that information.
Yeah, and the question is a matter of public record because of the state, being part of a state organization. And everybody knows basically what it is.
Well, I
We'll tell you.
right, but at some point, someone's going to have to formally tell me what it is. And you can't just pick up the phone and call me, because we don't do that. You have to file something in the court file or somehow come to an agreement on how it's going to
Don't
be
call
done.
me, file it. I like it. That's good stuff. That's nice.
Your Honor, ultimately, when you rule on these things, there'll be a number and it can be adjusted, I think, between counsel. The one thing I was going to say, it seems to me as we're thinking about it abstractly, that could impact it is what your ruling is on Sally Smith, because if they've argued she's not if you would agree with them on she's not an agent, now they could settle.
So is the plaintiff now saying she's not an agent so that we don't have to worry about that if I get there?
I didn't say that. I'm just saying, if you agree with that, I think they wouldn't get settled.
Okay.
We're gonna settle, I just want to move on.
Now they're just faffing around a little while.
Okay. Look, let's just refocus in here. On the specific question about, I will tell you this. No matter what, assume for the sake of argument, I say there's no juror interview. I'm not going to make any ruling before Christmas, okay? So that gives you all of next week to figure out these other issues, and then you can figure out how to convey it to me. Does that answer Mr. Whitney? I think it was Mr. Whitney. Since you have the timing issue.
We're not going to have a
or was that
ruling
Mr.
before
Elliott?
Christmas? Well, that's sad. How long does it take?
Okay. Does
Say
that
no.
time frame work for both sides to figure that out? Right. Well,
Thank you very
Mr.
much,
Altman, I
Rosemary,
see
for the
you're packing
compliment.
up. We still
Appreciate
have
that
other
in
things on
chat.
the
Thank you.
Actually, Your Honor, if you're ready to move to that one, on the sanctions.
Before we go there, I want to make sure I've closed the door on anything having to do with the abstract discussion about the potential entry of a judgment. So is there anything else on that issue?
Not for the plaintiff.
Okay, so we are now going to move to the next topic.
Are we still have more?
Your Honor,
And-
as far as the back and forth on the,
I thought we were done.
let's call it the
Well.
hustle of jeopardy type issues, we've agreed between us to defer that. If that's acceptable to the court.
Well, let me go over a couple of things first, because that's just one issue that we have labeled a sanctions issue.
All right, sanctions.
You know,
Start talking to
recollect
me.
when
Start
I
talking to
was
me.
assigned this case a few years ago, I came in and there was a lot of
The new
sanction
filing searches,
motions
exhibits, trial
that
transcripts.
were
Oh,
pending.
I thought
were
they
being
meant something
filed,
about
and
something
rightly
dealing
or
with juror
wrongly.
one that was filed.
And-
But okay, never mind. I don't need trial
I
transcripts.
basically started out taking the view that I'm going to push sanctions off to the side
Really?
as much as I could. I dealt with some. And I promised you all, both sides, that after trial, if you wanted to light each other up on sanction motions, I would make time for that. Now, you know, and I will tell you my thought process then was, well, once we have a resolution of the trial, I will then say, do you still want to light each other up with sanctions?
Yes, I really do. In
And
every
I
possible
made that
way.
offer, and so ultimately, if the answer to that is yes, I will keep my word on that. Now,
What do I have
do
to do?
know
File a
that
motion to renew?
the question of sanctions is going to be impacted by whether there is a new trial in whole or in part, because then we're back into trial mode. So I get that, but
If this winds up back
I
in the
need to
trial,
know
I'm going to be
from
a sad
each
uncivil.
side,
I
and
guess
I
it's
don't
good for
need
my
a final
channel though,
answer
because
this
it's more
moment.
coverage for me and people like it. So I
Is-
guess that's good. Not so good for
Are
mine
you
though.
all going to want to pursue sanctions against each other for all the number of issues that have been filed? And then frankly, someone's going to have to come up with a roster of all of, you know, I've got some that I know that I've put aside, but I mean, there's quite a few. And so, you know.
Right now, as a lawyer, I'd
and
be asking, do you
both
want me to
sides
file a
against
motion to
each
renew
other,
with
so
all
it's
the ones
not
that I
like
still
it's
think are
one
pending?
side
That's
only.
what I'd be asking. Because I'll do it.
I think maybe the question is, both sides be willing to just pack up tents and go home on this.
I suppose a sanction could theoretically result in a new trial, but that'd be harsh.
At this point in time to do that, and I don't,
Which is why I said I don't need a final answer right now.
you know, it's like everything else, we would be dropping things if they're not dropping things.
It's one hell of a sanction.
Maybe
I mean,
there's a way
it's
to
theoretically
resolve
possible.
this.
I've never heard of it, but I guess.
I think we need to see the final judgment first, Judge, to make that decision and obviously confer with our clients. We would point out that we.
You get final judgment.
Settlement that at some point will be-
The juror one can file his bar complaint.
Well,
Those tie into it.
attorney fees for substantive claims is not what I'm talking about. I mean, this is, they're saying that you did bad, you're saying that they did bad, and, sanctions. So I see Mr. Hunter standing up, so I'll.
I was going to make reference to the proposal for settlement matter. There are going to be some issues regarding the validity.
Don't worry if you can't hear. They're not really saying
I
anything.
assume there would be.
And there's also, in my mind, and I have not discussed this with Mr. Altenberg, and certainly not Mr. Elegant, but in my mind, if there's going to be litigation over sanctions or PFSs or whatnot, there's an issue of, if there's an appeal going on, there's got to be a relinquishment to deal with that. Is, in my understanding, or at least there's an issue about that. So that may factor into all of this.
Or maybe it's a collateral issue that I would still have jurisdiction.
Yeah, you would absolutely still have collateral.
I'm not putting you on the spot, Mr. Altenburn, but.
Yeah, why not?
Potential confirmed jurisdiction, I don't.
In our final judgment, still have sanctions. Why not? Tim Riggs with the 50 gift memberships. Thank you very much. That's very, very generous. Thank you very much, sir.
Well, attorney fees are collateral. That's easy, but that's on the substantive claims. I'm not talking about a proposal for settlement, attorney fees. That is fundamentally not what I'm talking about. I think we all, though, know we're talking about all the various different claims and sanctions. So I told you that if you wanted to light each other up, I would do it after the trial, and I'll stick to my word. But perhaps, depending on, and like I said, maybe whatever happens on these other motions will dictate it. But perhaps there's something else that y'all could come up with. Now, that raises the next question, which I did not put on here, is should I send you all back to mediation? And should I send you all back to mediation before I rule on any of these motions?
No point. No point.
Be very difficult for us, Judge.
There's no point to mediate. No.
We'll make a determination on, and we have been spectacularly unsuccessful thus far. Hopefully the verdict will change that. But I think it'll be difficult for us to do full solid judgment. Mark.
Would I have the ability to send you to mediation on a substantive matter, though, after I entered the judgment? I mean, I could send you on attorney fees, but, if I entered a judgment, or if I didn't enter it, I guess if I didn't enter a judgment, we're doing a new trial.
Tim Riggs has been a member for 10 months.
That
Thank you
would be
again for all the kind.
An easy one I could do. But if
gift
I entered
memberships,
the
that's really,
judgment,
really
then could
thoughtful.
I then send you to mediation at that point on the main issue? And I'm not sure I could.
The appellate court's going to do it in any event, one way or the other. They have every time I've seen.
I'm just waiting
The
for them to
fifth
stop
does, but
talking.
I'm not sure the
They haven't
second
been-
does.
They haven't been saying anything for a little while now.
Every other district has the authority.
They haven't been saying anything for a little while now, but I'm just waiting for them formally stop so that I can get my thoughts on the off chance they might say something.
You are ordering mediation after you enter the final judgment. Probably not going to go with the second.
I just don't know if I have that authority. And I, obviously there seems to be other issues out there.
We consult on that.
Yeah, Shapiro was there. Shapiro's there today.
Yeah, and I will tell you, Mr. Anderson, this isn't idle thought process on me. This has been an active thought in my head as to whether I should send you to mediation before I rule on any of these motions.
Thank you, Tim, for the $10 super chat.
Yeah, and I'm not
You saw me
asking
back
for a
on
final
Leonard French,
decision.
man. You've been here for a long
Perhaps
time. Man.
as
It's like 6 years
part
ago,
of the
man.
discussions on the insurance
Riggs,
issues that we
hardcore
dealt
fan.
with, you can confer with your
Tim
respective
Riggs is an
clients and then with
OG.
each other.
He was a fan of the channel before it existed.
Mediation before some of these lawyers were in such a
That's how OG is.
disagreement on things. If there's a mediation, it's probably after the mediation.
Your Honor, I guess I would chime in and say, I think if there were a judgment and you wanted us to mediate, I think we would talk. I don't see either side, from what I heard, wanting to object to talking. and
Anytime I can
mediation,
stop yawning would be
whether
great.
it's suggested or ordered. But we do want, as you know,
This is why I need a wife. I need a wife so I can say, could you please make me some coffee? So I'd have to get
I understand. Okay, well, when you convey the information about the insurance, give me some thoughts. It doesn't not have to be agreed to. You can each send me something if you want. Like I said, I'm not going to enter anything before Christmas. So maybe by next Thursday, you can file something and let us know. The clerk is closed on Friday, so there won't be anything that can be processed after 5 o'clock on Thursday. I have a case management note here.
Aw, come on, Crystal.
Is there
I'm busy right
anything
now.
that we need to
I'm busy right now. I could really
otherwise
use a cup of
address
coffee. I
that
don't
we
think
have
I'm asking
not
for too
yet
much.
addressed today?
Yes, sir.
Mr. Whitney,
We have a
Oh,
motion.
come on,
to compel.
guys.
We filed on the 6th.
Well, nice.
you can sit if you want.
I'll make you coffee sometimes
We
too.
filed a motion to compel regarding the immediate jeopardy documents. And
Both make each other coffee.
yesterday,
Fine.
we received a privilege log, and I believe the defendant filed a renewed objection to those documents. The court order produced immediately at trial. There were 2 boxes, an inventory provided to us. I'm sorry, an inventory of 2 boxes provided to us. The 2 boxes of documents have not been
If it's
provided.
really too much to ask my wife to make
We
me
would
a
like the
coffee,
court to compel the production of those
I guess
documents
you're not the
and
woman for me, is all I can say.
Not even the
If
unprivileged
it's really so
documents.
far
Now
beyond
that
the
they
bounds
filed
of
an
like, hey,
instance
honey,
of
could you
privilege
please
law,
make me some
renewed objection.
coffee? If that's really too much,
That will inform our
you're not the
decision
woman for me.
on whether we want to light each other up on sanctions. It
Presumably,
also
you'd like me to
informs
get you
the
some
prejudice
coffee or some drinks
against us
sometimes.
not
Like, hey,
having those
honey, can you
documents at the time of trial.
refill my water? Or, hey, honey, can you do this for me? Be like, do it yourself.
Well, okay, well, let me hear from the other side first.
Your Honor, we had the documents in question were made available during trial. The verdict intervened. Apparently, before anything could be done with them, they were then sent back. We had to re-get them back. We then went back through them. We never had an opportunity to look at objections or privileged information. We did that. We prepared a privilege log. We prepared objections. We sent those. We were trying to get them out as of last Friday or Monday.
My father makes
I was out of
coffee
pocket
for my mother every
On
day.
Monday, Mr. Hughes got ill. By the time I understood that
Because
that
we
had
love
not
each other.
happened, we had an agreement not to pursue matters related to sanctions at this hearing. So the material that is not objected to, that was ordered to be produced during trial, can be produced if that is going to move things along. I can get that to council either today or Monday, one or the other. But beyond that, we persist.
What happened to
in
Happy
our
Kurt?
objection.
It's
We'd
really
like to
early
have
in the morning.
A hearing on that
I've been
matter
up-
as it relates to the sanctions.
I've been up for 3 hours and it's really early. So what happened to really Happy Kurt is I got up before the sun.
Okay.
We're doing the best we
So
can.
You're sending over what you're claiming is not
Yeah.
privileged and
I think it is the little things in the
wanting
marriage.
to
I really agree with that
withhold
very
and have a
much. I think
hearing
it is the
as
little
to the
things.
balance.
Yes, sir, Your Honor, but.
Yeah, I think it is the little things in a marriage.
We continue to object to having been ordered to produce those materials at all.
I know, and perhaps we can just agree to
Yeah,
disagree
Kurt
on
needs
this
coffee.
issue, Mr. Hunter.
That's what I've been talking about for the last 5 minutes. That's why Happy Kurt isn't here right now. Kurt needs coffee, and then the chat's like, go make your own coffee. So what you want me to do? You want me to get up from my seat and go make coffee
Be that as it may.
so that I'm not streaming with you and can't hear the audio stuff.
And
So you want me to abandon streaming so that I can go make
subject to the
coffee.
objections that we've advised counsel on.
Stream is confusing
Mr.
to
Whitney,
me.
your side didn't file any motions for new trial or editor or anything else. So why do you need these documents if the court ultimately enters a judgment without any sort of new trial?
For the reason I mentioned, Your Honor, it will inform, there's going to be a discussion between counsel to understand about the desire to pursue sanctions motions. it will inform our decision there.
Why don't we, this is not a rule, let me just throw something out and get both sides' thoughts. What if Mr. Hunter sends over the non-privileged documents?
And here's a
I
thought: if
tell
you're my wife,
Johns
after you
Hopkins
make
that
me
they have
coffee,
to
I might want something else
preserve
from you.
Those two
Whoa.
boxes or whatever it ends up being.
Because, you know, marriage.
And then if we ultimately either have a new trial in whole or in part, we can address the issues on the claim privilege. If I enter a judgment, then you can have a further argument as to look at this privilege log, these specific documents, and perhaps I just do an in-camera as to those few. But I tend to agree with Mr. Hunter, like, what's the point if ultimately I'm entering a judgment? And I hear your argument about the sanctions, and that probably is valid, but what about that, what I just outlined?
That suggestion is fine with plaintiffs.
Subject to our objection, Judge, I will refer.
And I know in the first instance, you don't think you should have to turn them over at all. I get that. I disagree, but, you know.
I should add to this mix that we have an agreement, I believe, with counsel that any production that we make is subject to confidentiality.
And I think we have a confidentiality order and you can produce under the confidentiality. I'm fine with it. So I will go ahead and direct Johns Hopkins All Children's Hospital to maintain those two boxes. Go ahead and turn over the next couple of days the non-privileged documents, and then we're not going to do anything on the claim privilege until we figure out what actually gets entered as far as new trial or judgment or some combination.
And we are producing confidentiality.
Under the confidentiality, yes, sir. And any other case management related item we need to address before we adjourn for the day?
See, thank you, Iowa. Yeah, you're the kind of woman I'm looking for.
Okay.
That's the
I
kind of woman
appreciate
I'm looking
everyone
for.
being
Are
here.
you
I know this is
single?
a difficult
And
subject.
35? Do you not have
And there's a
children?
lot of
Call me.
divergent opinions on it, but I do appreciate y'all's work today during this hearing, and we will be in recess. Happy holidays, everybody.
All right, we're done. Thank God. All right. So I can tell you a little bit about what happened as we sum this up. Trust me, you didn't miss anything of value in like the last 20 minutes. But I'll give you the summary anyway. He's like, oh, we can't hear. Trust me, you didn't miss anything. I was listening. You weren't missing anything. All right, so here's what happened. So first of all, this is normal. This process is normal, and the judge's questions are normal, and there's nothing unusual about what's happening here, except, you know, Jay Hatch's position is incredibly feeble. But it's a standard thing, right? So as I said before, you know, you ask for a decision in your favor basically every possible step of the way. And Maya's team did too. Of course they did, right? Because the very act of filing the pleading is an act of, hey, can we get a judgment in our favor, right? That's the initial complaint is, hey, judge, you want to give us what we want, right? So, and then Jay Hatch files the motion to dismiss because it isn't supported at law. And, you know, we argue about that for a while. And if you're Toddy without a crystal ball, we argue about it for the next year. In so many emotions and panoplies, it was breaking my brain. We were stuck in step one. We were stuck in step one forever. In fact, we never made it out of step one. So bad. All right, anyways. So once you get past the motion dismiss, then typically you're in discovery. And then you have some discovery arguments about it for a while. And then at some point you have a summary judgment motion, although these guys seem to like many summary judgment motions where you're like, hey, Your Honor, we've had discovery now, and, you know, this is what plaintiffs said they thought the facts were in their initial complaint, but now we know the facts because we've done discovery. right? And in the best possible light, they didn't have the facts. They have misled you, court. They said they could prove things in their pleading, their complaint, that they can't prove. They haven't been able to produce evidence. So you should rule against them because there's no evidence to support them. You know, they went forward on an illusion, and the illusion has been exposed through the discovery, which has not revealed what they thought it would reveal. Right? That's summary judgment, right? And so then as a judge, you're basically like, okay, taking light of the facts most favorable to the non-moving side, because summary judgment goes both ways. Both sides can get summary judgment, obviously on different things, not on the exact same thing at the same time, but they can get summary judgment on different things. It's like taking the light in the non-moving party both ways. Then, you know, is there sufficient facts to allow this to go to a jury? Or taking the facts in the most favorable light to the non-moving side, can a jury find this, right? And so the judge makes that call, usually once. Here, 52 times, which continues to blow my mind as completely illogical and unreasonable. You know, it blows my mind.
On the false imprisonment, if this...
So it blows my mind as completely irrational and stupid. All right. So then we finally get to trial eventually, right? And then we start actually presenting evidence. Now, the evidence we're going to present at trial is not going to be the same that we presented in discovery. And that can happen for any number of reasons, right? A witness, we're not going to call the same witnesses because we don't have the same time, right? The amount of information you uncover in discovery can be thousands, tens, hundreds, millions of pages of stuff. It can be a lot, particularly in this kind of case. It's a lot. And so you can't present all that stuff. So first of all, the stuff you're going to present at trial is necessarily going to be some slice of the information that you have available to you. And second of all, that information may not be able to be presented because insert reason, the witness has recanted or whatever, or is unavailable and blah, 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 whatever, right? So, you know, so then we have the actual trial where the actual evidence actually happens and we actually know what they're actually arguing for real because it's really happening. Okay, great. So now we want to move at some point, and probably multiple points, at directed verdict, right? So throughout trial, we're going to ask for directed verdicts and mistrials and all that kind of shit. And basically we're like saying, hey, Your Honor, you know, they haven't presented enough evidence. Can we win? You know, they fucked it up. They fucked it up, and this shouldn't go to the jury. And the judge was not, I don't think during the trial, but certainly before the trial, was dismissing counts against Johns Hopkins. So he was doing that and doing some other things in relation to what would be presented. And so, you know, like, hey, basically their side screwed it up. Can we win without going to a jury? And so then they consider that. And so where we are now is the very end of that road, where you have to make these arguments because you have to preserve your issue, right? You have to make the argument that we should win so you don't waive it, right? You use it or you lose it. So this is necessary to do. And there was nothing unusual about the process as you saw it, right? This is perfectly standard. Now, of course, the issues that are being discussed are not perfectly standard, because normally we're not saying, how about a jury interview? And also juror number one is sending secret Nazi communiques, right? So it's unusual in that way. And also, it's not unusual to deal with what you got. So Johns Hopkins has the problem of the facts kind of suck for them because there's a lot of evidence against them, right? So, you know, ideally you want to make pure legal arguments if you can. You know, hey, Your Honor, you screwed up the law, right? You screwed up the law. You screwed it up before. We've been trying to tell you. Would you like to reconsider now? I'd be like, oh my God, I can't believe I screwed it up that hard, right? So ideally you want to make legal arguments. And if you can't do that, you want to make factual arguments, which Johns Hopkins tried to do. But the problem with that is at this stage of the proceedings, because we actually had a jury that actually sat and actually decided things, it's no longer just what the judge thinks anymore, right? It was all about, can a jury do this? But now we're talking about what a jury did. They've actually ruled, right? So Johns Hopkins arguments basically boil down in substantive part 2 here's a lot of reasons that the jury should have found for us. And I'm over like, well, you know, those are good reasons perhaps the jury could have found for you, but they didn't. Right? So like, yeah, here's this email from Maya's mother. Here's this thing that we did. Here's this thing that we did. You know, probably wasn't unreasonable to do this. Probably wasn't unreasonable to do that. Blah, 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 blah. And I'm like, you know, as a judge, even if I granted like everything you're saying, Johns Hopkins, even if I granted literally all of it, I can't fix this. Because the standard is essentially no reasonable jury. Put it in whatever language you like, but that's basically what it boils down to, right? No reasonable jury. Manifest weight, blah, 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 blah. But you know, this is what we're talking about, right? It can be phrased multiple different ways, but it's essentially the same concept. You know, no reasonable jury could find this fact. You know, because the evidence is so overwhelming, external influence, whatever, right? No reasonable jury could find this fact. But if there's any reasonable way for the jury to find it, because the jury, of course, is the finder of fact, so they're allowed to believe witnesses or not in any degree they wish. They can believe a witness in whole, in part, or not at all. They can believe a witness is lying about something, but not necessarily everything. It's up to them. And also how much weight to give a witness is up to them. So they could simultaneously say, if they wanted, hey, this witness is lying about literally every word that comes out of their mouth, but they're just not that important of a witness, so I don't care. That would be a thing the jury can do, because the jury's the finder of fact, and it's up to them to decide how much to believe it and how much it matters. So they can choose to believe an extremely large lie doesn't matter, and an extremely small lie does, because it's up to them. It's up to them. So basically, any reasonable way that any reasonable juror could possibly weigh this in any combination is a valid choice. Anything they could do is up to them. And apparently what they did is said, Johns Hopkins sucks balls. And they should suck it. And so, you know, Johns Hopkins is all over here like, well, here's a whole bunch of facts that help us. And I'm recorded like, what do you want me to do about it? You know, what do you want me to do about it? And it's like, so you can't win on the law because you don't have the law. As desperate as you try, because like, you know, there's nothing there. And you can't win on the facts because we already had that argument. 6 people decided your fate. Eat it. You know? So, yeah. And basically, if you like to view it this way, you can view as what happened just now as an appeal before the trial court. Because that would also be a valid way of looking at it. Basically, it's the same thing, right? It's the same issue, basically, fundamentally, you know, to boil it down. It's like, okay, either there's an error of law, or, you know, manifest weight, or, you know, some external influence, right? So basically, you're getting a preview of the appeal, right? It's an appeal before the very same judge who heard your case in the first place, but that's okay. You are allowed to do that. You're allowed to make an appeal to the district court, and the district court is not bound by their own findings. The district court can change their mind because they're in review of themselves. And district courts do change their mind from time to time on issues, as the case may be. So we've got a bit of a preview of their appeal. And based on their preview of their appeal, I'm not really seeing much hope for them at appeal. So it's not looking great. Because it's like, well, you know, and also, of course, as the judge pointed out on the Court of Appeals will also point out, not only does the judge have to make a mistake, but they have to make a mistake that matters. And that's the real tricky part, right? Finding a mistake the trial judge did is easy. Easy, right? You can't sit for 9 weeks and not make a mistake. No one is that good. No one is that good, including me. I am not that good. I'd like to believe in my own conceited will that I'm that good, but the truth is no one's that good. The odds of me sitting through a 9-week trial as a judge and not making a mistake are essentially 0. So finding something the judge did wrong is easy. Finding several things the judge did wrong is easy. The next thing is the really, really tricky part. Did it matter? and probably not, right? So like, for example, just to illustrate the point, like suppose that, they made a motion to exclude a witness. And suppose I, as the judge, said, nah, that witness is going to testify. And suppose the Court of Appeals says, shame on you, Judge Mueller, shame on you. Shouldn't have allowed the witness to testify. That was a bad decision. You're a bad judge. Great. You've got past part 1. Part 2, does it matter? Right. So next thing the Court of Appeals is going to ask themselves is, okay, we're going to go into our minds, because we're smart judges. We're going to go into our minds and pretend that evidence was excluded because Judge Mueller was a bad judge, right? We're going to pretend in our minds that evidence never happened. Okay. Is there still enough evidence for the reasonable jury to reach the conclusion they did? Right? And so, yeah. So basically, it takes a pretty big F up. It takes a really big F up, right? To win this. It takes a pretty major screw up. So you don't have a lot of hope. So yeah. And I don't, and Judge, so then the only other thing that happened is we had the sanctions, which Judge Carroll says, well, I've been holding all these sanctions in abeyance this whole time, which, why? I don't know. And I was like, I promised you guys I'd hear the sanctions at the end of the case. Now, why you're not hearing sanctions during the case, I don't know. Because, especially like earlier on in the trial, like before you got to court. Like I could understand things that happened during the trial, not doing a sanctions motion for in the middle of trial because it would disrupt the flow of the trial, unless it's like grievous. But all that stuff that happened before the trial, you should have heard that stuff long ago. All right. And the judge is like, well, I've been holding all this in abeyance. And if you guys really, really want me to do it, I promised I would. Apparently secretly begging and hoping that they'll let it go. So I don't know what this judge's problem is. And I don't know what the problem was with the 2 judges who preceded them. Apparently they're all a bunch of pussies and don't have big judge balls. So yeah, so I don't know what's going on in that. I don't know what's going on in this courtroom. I don't know if it's intimidation because it's Johns Hopkins. I don't know if it's intimidation because the lawyers. I don't know if it's intimidation because they're worried about their elections or what the hell's going on. But none of them have big judge balls. And of course, you have to assume, because why wouldn't you? You have to assume that he's not going to issue sanctions. Because why would he? Right? I mean, none of them have done it this far. So why would he do it now? And if he's going to do it now, it's going to be probably token. So he's not going to do anything substantive. Maybe he fines him like $1,000 or $5,000. So like, but he's not going to do anything major because he doesn't have big judge balls. So that is the short of the hearing. That's what we heard for 3 hours. And of course, Maya's attorneys are completely correct because they have the facts and the law in their favor and the jury ruled for them. So, all the presumptions are now in their favor. They were for Johns Hopkins for a while, but not anymore. So, yeah. Why didn't the judge rule on anything? I don't know. I'd be issuing orders orally, and I'd just be making summary decisions. Just be like, do this, no. So, yeah. Kurt for Supreme Court, I will judge with big balls. Yeah. So, yeah, basically. Big brass ones. So if juror 1 makes a bar complaint, what are the possible outcomes? Well, the possible theoretical outcomes are no action, private reprimand, public reprimand, and disbarment, either temporarily or permanently. Those are your range of options. Suspension also, I suppose, which is effectively disbarment temporarily, but suspension. So those would be your options. And my expectations for the bar are somewhat low, But they do have a pretty good cause of action here. 8.4 talks specifically about not unduly embarrassing the juror. And I think they've got a pretty sizable action, plus other misconduct and stuff like that. So, yeah. At what point does the judge get a talking to? He won't. He won't. At best, and it's hyper unlikely, but at best, the Court of Appeals will slightly admonish him. But they're not, they don't tend to, right? They don't tend to fault judges for not doing things. They only tend to fault judges for doing things, right? They only tend to fault judges for going too far. And so judges kind of learn to play it safe because, you know, they'll never be punished for that. Tim Riggs gives another 50 gift memberships. Incredibly generous. Incredibly generous. Yeah, there's really no good way to pick judges without bias. Elected judges need backing and platform. Yeah. So, yeah, there's no good way to do. There is a human factor in this that cannot be avoided, right? Whether judges are appointed or elected, you know, they're at the mercy of somebody. And, you know, you got to make your boss happy, whoever that is. So that is a bit of a problem. I don't know why the people would necessarily, you know, Judge Carroll rules against children, you know, so you know how the attack ads work, you know. So yeah. Let me read through your super chats that we've had during the stream. And we can answer any further questions you guys have along the way while I'm reading them. So I'll do my best to read both at the same time, and we'll go from there. Tony P gifted 10 gift memberships. Fiona W gifted 10 gift memberships. Brian Gibson has been a member for 13 months. Thank you very, very much for hitting the beautiful, beautiful join button. Brian Gibson then gifted 10 gift memberships. Mandy Me has been a member for 15 months. Thank you very much for hitting the beautiful, beautiful join button. Not a banned account says, why have hearings after the verdict? In Law and Order, you have a verdict and then a guilty plea. Quick and simple. Yeah, Law and Order isn't necessarily reality in any sense. It ignores all the paperwork. There's a lot of paperwork as a judge or as a lawyer. It's not all trials. In fact, it's mostly none of it is trials when you finally add it up at the end of the day. Yeah, the going into court is the unusual part of the experience. DeNovo gifted 20 gift memberships. Thank you. And Ann Rasmussen gifted 10 gift memberships. Thank you. Ann Rasmussen, has been a member for 8 months. Thank you for hitting the join button. Matt Bond has been a member for 3 months. Thank you for hitting the join button. Lyndon Martingale has been joined as an uncivilian. Thank you very much. Oh, by the way, while I'm thinking about it, just as a friendly reminder for the 1,700 of you, if you have Twitch and have Amazon Prime, you can link up your Amazon Prime with Twitch and subscribe, which is the equivalent of paying me, but it costs you nothing. So you support the channel financially, and you don't pay me. Jeff Bezos pays me. So, and I do think you have to renew it every month. So, you know, you have to set a calendar to remind yourself that you have to do it. But I would really appreciate it. It's a substantial help to the channel financially, and I very much appreciate it. Yeah, help me take money away from Jeff Bezos. Help me take money away from Amazon. You know you want me to take money away from Amazon, Jeff Bezos. You can do it. Please help. Great. Matt Bond gave $2 Australian to say objection. Nah. Fuck you means nah. Yeah, very well. Nate the Lawyer, good friend to me and the channel. Nate the Lawyer, kick ass. If someone drop his link to the channel, please. Show Civil some super chat love. It helps us as content creators to continue to make this great content. No amount is too small. Thank you very much. AKA the Cat Lady gifted 10 gift memberships. Lynn Barry gifted a lemon, who is apparently singing me a song as roses develop on a bush. Thank you very much, Lynn. Babs Austin said, appreciate you making clarifying remarks. My son is a lawyer, but no longer taking my calls. Well, I always try. I always try to give good legal advice, and I hope things between your son and you improve. Sarnism gives $2. Say, J Hatch, you lost. Good game. No re. Go bleeping next. Facts. Whiskey 77 has been a member for 11 months. Camille Barkley, $4.99. I live in this country and defense for not serving the next time I'm called for jury duty with all this BS. You know, a lot of people have that feeling, Camille, and it's for that reason, in large part, that I really hope the bar punishes them. Because if the bar punishes them, they might restore confidence to the jury system that this is unacceptable. So it's asking for a lot, but I really hope they get a public reprimand. I really hope they do. It's a lot. It's a big deal. It's a big deal. Even a private reprimand's kind of a big deal. It's a big deal. But getting your ass hauled before the Florida Supreme Court and being forced to stand in the well as they admonish you publicly on the record, oof. It makes you want to die inside. If you have any integrity left, which Johns Hopkins lawyers might not, but still, woof. I just want to die. Terry Zaleski said for $1.99, said, did we not already have the trial? We sure did. But we're going to be doing this a couple more times. Welcome to Appeal Land. Swall Phoenix became a member for 99 cents. We appreciate it. In Love with Law became an uncivilian for 99 cents by hitting the join button for only 99 cents. We do appreciate it. Michelle Marnard has been a member for 3 months. Thank you. Just BKZ has upgraded their membership from 99 cents to $5.99. What a generous person to join at a higher level of uncivilianship. Thank you so much for your higher level support. We really, really appreciate it. Yeah, the Florida Supreme Court publishes public reprimands on YouTube. Yeah, I'm aware, Tim. I'm aware. It's glorious. In Love with the Law for $5 says, do you think the judge will end up ruling an interview should take place? No. I continue to think the answer is no. It's insane. Ash Nicole said, Juror 1 may have plans. Yeah. On January the 3rd. Yeah. BG gifted 5 gift memberships. Carol Blankmore gifted 10 gift memberships. BGS JMCK says, we need Anderson. Elligott isn't passionate enough. Well, I don't necessarily think you need passion. You need zealousness, not necessarily passion. And I think you can be a good lawyer without passion. And I think you might even be able to be a great lawyer without passion, because if you can just remain purely objective and just do it in reason and logic and facts, that can really work too. So I don't think lack of passion isn't necessarily a problem. It's just how you go about it. Like many things. Cynic in Chief is a member for 1 month. Thank you very much. Rabbit, who has Rabbit by their name, that's cute, has been a member for 6 months. Cynic in Chief says, do they even have guns or rights in Canada? At least theoretically, they're supposed to. They have a charter, so possibly, yes. Cherry and Max says, probably dumb question, but why would a judge ask about what an interview with Juror 1 would look like? That's a great question, right? So the judge wants to hear from the parties about what they think the law is, right? The judge is going to do their own research. And so the judge asked a lot of questions like, what would a remitter mean? What would it mean for me to do that? Would we have to redo this part of the trial or this part of the trial? What would that actually look like? Right? So he wants to hear about that from the parties, about what they conceive that looking like. So he can understand their perspective on the thing. Perfectly normal question. Perfectly normal thing to do. And so, yeah, asking about what would an interview look like. Okay, suppose I grant an interview. What would that actually mean? How would we actually go about it? What are the mechanics of that? And then, of course, Johns Hopkins basically didn't answer the question. They just kept talking about all the reasons you would. And, the lawyers from Maya gave an answer. It's like, well, it'd be conducted by Your Honor. That's how we normally do that. And, we do it that way. So, that's their answer, right? So, and it's like, okay, how should I structure this judgment? Do I need to do this or do I need to do this? Does it need to be this way or does it need to be this way? The judge wants to check their own thinking. It's a perfectly normal thing to do, right? Even if you've been on the bench for a long time, judge wants to check his thinking, make sure he's doing it right, particularly in a highly high-profile case like this. The judge would be particularly well incentivized to make sure that he's, minding his P's and Q's because he knows and everyone else in the room knows appeal. So the judge wants to do his best to avoid shit on the record. So asking the parties, hey, what does that mean? What should I do? How would I go about doing that? What does that actually mean? What are you actually asking me for? You're asking me for a remitter. Okay, what would that actually mean? Can I just do that? Does it mean I have to have a new trial? Is it just as to that part? Is it just as to the punitives? Is it to the whole thing? What does it mean? What does it mean for me to actually do that? So yeah, so that's all that stuff. So it's perfectly normal. Didn't have any problem with it. You'll hear appellate judges do the same thing. You'll hear appellate judges do the same thing. Hey, counselor, what's your understanding of the law? If I were to decide for your favor in this way, what would that mean for situation X or situation Y? They ask counsel about what the law is all the time. It's kind of what appeal lawyers do, answering questions about the law. The appeal judges answer the questions, and they also ask them. And the lawyers are there to teach. It's part of their job. They're there to teach the court. Nothing wrong with that. So yeah. The Supreme Court of the United States does it. Supreme Court of the United States, it does it all the time. Counselor, if we ruled for your favor that way, what would it mean for this situation? Or how about this situation? Or how about this situation? Or what would that look like in practice if we actually did that? What would that actually mean on the ground? How would that actually manifest itself in some way? Did they actually get the IJ finally? After all this time? So yeah, it's totally normal. The bar does not teach court. I disagree completely, Karen. I disagree completely. We literally do. It's what having a JD means. Lawyers have JDs. JD means Juris Doctor. Doctor means teacher. Juris means law. So you're literally a teacher of law. That's what Juris Doctor means. That's what JD means. I'm literally a Juris Doctor. I'm literally a teacher of law. That's what I do. Yes, you absolutely do teach the court. Of course you do. That's your entire goal as a lawyer, especially on appeal. Well, I don't know if especially, but it's the law, especially on appeal. But yeah, you're always trying to teach the court. You're trying to teach them, and you're trying to teach the jury. You're trying to teach them. And of course you are. That's exactly what your job is. Here's what the law is, Your Honor. Here's what I think the law is, Your Honor. I don't know if you considered this one, Your Honor. Here's how I think that would work, Your Honor. Especially because the lawyers are going to be more familiar with the case because the judge probably has 10 other cases in their mind, and these lawyers probably have been focusing on this more. So it's quite possible. So yeah, absolutely they teach. It's what they do. It's what lawyers do. They teach. It's in the nature, we teach our clients. We tell them what the law is. We tell them about the facts. We teach them about the obscure legal terms. We teach them about what the other side means about things. We teach. It's literally in our definition of our job. Mandy Strong says, 9D99 says, will the judge make any rulings today? I don't think so. No, he won't. They're held in abeyance until after Christmas. Patricia Bell gave 5 gift memberships. Cynic in Chief gifted 5 gift memberships. Catherine Green has been a member for 1 month. Beata Responsens has been a member for 99 cents. Debs, who gifted their 5 super chat ever, said, I just got to the Pop Brothers Shut the Fuck Up Friday. Please, Judge Carroll, tell the defense to do that. I appreciate it. Tim Riggs has been a member for 10 months. Thank you for hitting the join button. Lynn Britton has been a member for 5 months. Thank you for hitting the join button. Thank you, DSN, for the 5 gift memberships. Newt has been a member for 43 months, a long time uncivilian indeed. Tim Riggs gets $10. Say, just want to say I first saw you way back on videos with Leonard French when he asked you to come in with help with patent law stuff. Thrilled to see your channel grow. So yeah, so that's how big that's how big a fan Tim is. He's a fan of the channel before the channel ever existed. He is an OG. OG, man. Bluefin became an uncivilian by hitting the join button for 99 cents. Thank you for the support. Bluefin gifted 10 gift memberships. Becky Mackey became an uncivilian for 99 cents. Thank you for hitting the join button. Tim Riggs gift $5. Say the bald spots and bad combers in this courtroom drive me nuts. Just take the plunge and lawyers and judge save it all. I don't know about that, man. I'm not sure about that one. Iowa Backyard Comp says, I'd have coffee ready for you before you woke up. I'm that type of good wife. I'd bring you more if you need it. Yeah, I don't know why this is so... I don't know if the chat is just harassing me or just prodding me or what the deal is. But, you know, husbands and wives should want to do things for each other because they love each other, right? So I would do things for my wife all the time. You know, it's interesting because when I think about the things that I most value in my past relationships, I think about the really small things. Like I go thinking about my former girlfriend at the time, and she was my girlfriend at the time, former girlfriend now. But I think about her, and she lived with a cat, and there was a little convenience store like right around the corner. You know, it was a very small little convenience store. And, you know, as I would go visit her, sometimes I'd just go buy her paper towels or kitty litter or toilet paper or some chocolate that she would like or something like that, you know? And that's what I think about. Those are some of the fondest memories I have. Those are some of the fondest memories of my house. I have literally giving my girlfriend a gift of cat litter because I knew she needed it. And that's what I think about. So like, yeah, the small things are really important at weddings and marriages. You know, marriages are, at least in my view, all about the small things in the everyday. Marriages are definitely not about the wedding, a mistake I think many people make to a large degree. And marriages are also not about the trip to Cabo or, you know, the fancy dinner out or the elegant gala. Marriages are about the everyday. Marriages are about, at least in my humble view, you know, how you wake up together, how you go to sleep together, how you greet each other when you come in the door. You know, it's about the little things. It's about the fact that my wife would like something. And I get it for her because it makes me happy to see her happier. It's about the fact that my wife wants to get me things because it will make me happier and she wants to see me happier. So I don't know why this proposition of if I had a wife, I'd ask her to make me coffee because I can't get up and stream, can't get up from the stream right now, is apparently the most controversial opinion of all time. I don't get it. I don't understand. I don't get it. It was the phrasing. If I had a wife bring me coffee, okay, I might have phrased it in a slightly humorous way. But, dude, come on. Give me a break. Don't parse my words that closely. That's not fair. That's not fair and uncivil. Oh, you said if I was married, you say, wife, bring me some coffee. That's rude. Lord have mercy. Lord have mercy. Give me a break. Yeah, I would say please. I'd say please. Give me a break. And if I said it a little tartly that occasion, you know, as a one-off, I wouldn't expect her to really mention it, you know, give me a break, guys. Jeez. And then it's like, yeah, if after I asked you for coffee, I want for something else. And one of you, I'd asked for something else. And one of you guys was like, well, if you're going to ask for that, that's going to require a lot of payment. I'm like, what the hell are you talking about? Require payment? What the hell? What the actual fuck are you talking about? It's like on the off chance that I might want to have sex with my wife. Oh, you know, geez. You know, that's asking for a lot, Kurt. Really got to pay up. You know, theoretically, she'd want to have sex with me because she loves me and stuff. Lord. You know? Damn. If you're viewing sex as a payment for something, this marriage has gone horribly, horribly wrong. Any wife wouldn't tell me to pound stand if I said something in the wrong manner? Probably not. No, some wives might be a little bit more gracious on a one-off. I don't think every wife would necessarily, you know, thrash her husband over the head because he made a slip of the tongue and said, get me some coffee instead of please get me some coffee. No, I don't think every wife would immediately resort to, you know, what the hell are you saying? You didn't say please. Bah, 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 bah. No, I think a wife might give some gratitude, might give some slack to her husband because, you know, love. You know, yeah. But apparently my views are naive or something. I don't know. I don't get it. Tim Riggs gifted $5 to say the sense of desperation from J-Hatch should have cleared the courtroom. Iowa off Backyard Cam gifted 5 gift memberships. It was my tone. You have an edge in your voice when you casually mention women. Okay, perhaps. Fair point. Perhaps there was something in my tone. I've been accused of being misogynist before, and I really don't think that's fair. And I don't think that my tone is really different when talking about men versus talking about women. You know, I tend to be equal every way, but, you know, possibly, maybe there was something in my tone that was not the right tone. So if that's the case, then I apologize, and I'll try to watch more closely for my tone in the future. I didn't really expect it to be parsed that closely, but fair enough. Yeah, fair enough. And my tone with my wife would be different. I'm more free in relationships. The caring and nurturing side of myself definitely comes out a lot more in relationships because they're really important to me. So, you wish Kurt would not sit there and talk over arguments for 5 minutes? Just trying to engage with the chat. Yeah, I don't know. It's always difficult as a creator to know what to say and what not to say. You know, it's always difficult as a creator to know what to respond to and for how long and stuff like that. And I don't know. And also, you can't make everyone happy. Some people think you didn't say enough. Some people say you said too much, blah, 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 blah. Great. Tim Riggs gifted $10 to say, regardless of their extremely offensive attacks on Juror 1, there are 5 other jurors that found against them. They should be moving to appeal instead of defaming the juror. I agree. Snazzy Trinkets Jewelry for $10 says, when this judge said, what's the point of receiving the IJ report's evidence now? He ordered them to do so. Judge seems to be backtracking on his own judgment. Facts. Roxy McFly gifted 5 gift memberships. Tim Riggs gave $2 super chat, says, okay, I'm doing this because I want Kurt at 1,000 likes. That's very thoughtful, Tim Riggs. And then immediately gifted 50 gift memberships to help me get at 1,000 likes. That's very nice. Yeah. DSN gifted 5 gift memberships. Tim Riggs for $5 says, I don't know if you're aware, but the Florida Supreme Court publishes public reprimands on YouTube. I've been watching them. They sure do. I think it's great. Let's really make that public reprimand public. Preach. Chantel Caesar gifted $5 Canadian said, I'm behind. Didn't realize you were a vet. I'm not a vet. I don't know if I said I'm a vet. I'm not a vet. I don't know if I misspoke. So if I said something that implied that I was a vet or even said I was a vet, it's a horrible, horrible slip of the tongue. Sorry. I am not a vet. I would never claim to be a vet. I would never, claim someone else's honor because that's a really, really scummy thing to do. So, sorry, Chantel, if you heard me say I was a vet. I apologize. That's a horrible mistake. I don't believe in stolen honor. Stolen honor is some bullshit. Newt gifted 5 gift memberships. Jules Buddha gifted 20 gift memberships. And DSN has been a member for 6 months. And those are all the super chats we had. And then we had some people on Twitch. But I don't know if there's a way for me to see all the Twitch stuff I got historically. There must be some way for me to pull it up on the back end. And I suppose now's a good time as learned any. So stay with me for a moment as I try to learn how a Twitch works. Do 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 do. How does a Twitch work? How can I find all the things that happen? How does a Twitch work? How can I find the chats that came in? There must be an option somewhere in the Twitch settings dashboard. How do I Twitch? I don't know how it works. Let's see. Tim Riggs says, for $5, don't worry too much about what not to say, brother. Wouldn't be here if I didn't accept you how you are. Appreciate it. Yeah, something via Twitch during the stream was a pain in the ass. Sorry to hear that. Yeah. How do I Twitch? I don't know how it works. Apparently 5 of you used the beef fish emoji today. I see that. That's nice. I failed. I failed. I'm trying to see if there's an option in I'm in Creator Dashboard. I'm trying to see if there's some sort of option in Twitch that will give me a record of like everyone who sent me bits or subscribed or something. Is there a list of like activity that way so I can specifically thank everyone who did that? I assume it's in Creator Dashboard somewhere, but I can't find it. Is there a record of like everyone who joined and everyone who bidded and everyone who financially supported during the stream? Is there some record of that inside Creator Dashboard? Help. You don't see it from your end? Damn. Can you see it via Stream Elements? That's an interesting idea. Let's find out. Oh yes, the mod view. Click the sword on your comment on your Twitch stream. Yeah, on Twitch stream. And it just gives me a summary. How do I Twitch? I don't know how it works. So if I click on the little thing, it gives me a menu. I don't see a menu. Oh wait, there it is. Maybe mod view. Is it in here? Is it in here somewhere? Mod actions. It gives me a list of all the mod actions. Automod queue. Chat. Come on. It's got to be here. I don't see it. Left-handed gave me some ideas. Hold on. Let me go back to YouTube chat so I can see what you're telling me. How do I Twitch? I don't know how it works. Let's see. Left-handed said on the left-hand side of the page, you'll see a history of followers, timed out bans. Well, I see a list of, hold on, left-hand side, active mods, activity feed. Activity feed? No. Whispers? No. Active mods? No. Activity feed? No. Okay, yes, I can do this. Okay. So bits, followers. Okay. Okay, we're getting close. We're getting close. Gifted subs, raids, subs. Okay, I think this is a complete list. I think left-handed taught me a thing. Okay. Is it just the one? Oh, no. Okay, how do I make this go away? Aha! I think you taught me a thing. Great. Thank you, Left Hand. I appreciate it. All right, on Twitch today, we had Clop who followed me. Texas Girl XOXO followed me today. Nate0490 followed me. Pine Needle Protagonist subscribed with Prime 2 hours ago. Thank you very much, Pine Needle Protagonist. Scotty Fixer subscribed with Prime 2 hours ago. Thank you very much, Scotty Fixer. Milan Ism followed me. Deborah J Hatch followed me. Pin Neil Protagonist followed me. Janelle Silver followed me. Smurfana followed me. Nice name. Spooled72 followed me. KT Nurse 54 followed me. Scotty Fixer followed me. New to UK subscribed with Prime 2 hours ago. Grizzly followed me. Octorosopus. Orctopus Aurorus. Orctopusarus Subscribe with Twitch hours 2 hours ago. Thank you very much. Sarnism subscribed with Twitch 2 hours ago. Thank you. Crazy the Reza subscribed with Twitch 2 hours ago. Thank you very much. And also followed me. Thank you very much. Sir Frank Otter gifted a membership sub. First gifted membership, I think. Thank you, Frank the Otter, for the gifted membership. That's very cool. Just XUXA subscribed with Prime 3 days ago. Okay, cool. So now we have a feed of all those things. Thank you for teaching me a thing. I appreciate you have taught me a thing. You are great. Great. So I can do that now. Yay, I learned. All right, what else do we have to talk about while everyone give a heart to Left-Handed for teaching me a thing. He deserves a little love in chat. All right. All right, I guess I'm going to sign off for now. This was a good stream. Jury questionnaire, any merit? No, I don't think so. I'm going to make myself some coffee in lieu of a loving wife. I'm so lonely. I am so incredibly lonely. You know, there's people who say that loneliness can be worse than smoking for your health, and I tend to believe them. Loneliness may yet be the death of me. I hope Mrs. Uncivil's out there somewhere. Have I considered a pet? Sure, because a pet is definitely a substitution for a wife. I've been Uncivil Law, and until later, my friends, I hope all is well. Cheers, my friends, and goodbye.